Mr. Karim Singh, Integrity Initiative, and also Mr. Pusetso Moraperi, also from the Integrity Initiatives. Mr. Robert Rose, the chairperson and founder of Good Governance Africa. Dej Hastrap, the vice chairperson of the Good Governance Africa. The staff from the SADC Parliamentary Forum here present in this room. Also staff from National Parliament, all other guests who are in here, ladies and gentlemen. My name is Joseph Manzi. I am the Director of Programs and the Parliamentary Business in the SADC Parliamentary Forum. I will moderate the first part of this meeting, which is the official opening side of the meeting. Let me welcome you all at this point in time to this meeting, more of a workshop, but interactive one. The meeting has been organized by the SADC Parliamentary Forum in collaboration with Integrity Initiatives International and Good Governance Africa. The program, I'm sure we have seen it. I will not go into details, but we'll start with the official opening part of it. Once that is done, then we'll hand over to the resource persons that have been designated to facilitate this workshop. At this point in time, even the objectives for this, specific objectives for this workshop, whose title is Advancing Governance Through Business and Economic Integrity, exploring the role of the International Anti-Corruption Court. I'll repeat the title of the meeting or the workshop. Is Advancing Governance Through Business and Economic Integrity, exploring the role of the International Anti-Corruption Court. That's the main theme or topic for this workshop. So the nitty-gritties in terms of the what goes into that, or unpacking the title, I think that's what the resource persons are going to do. Honorable members and ladies and gentlemen, it is now my singular honor to invite the chairperson of the Parliament of the Standing Committee on Trade, Industry, Finance, and Investment to officially open this meeting. Honorable Mendes.
Muito obrigada a todos, honoráveis colegas, membros do Fórum Parlamentar da SADC, senhora Secretária-Geral do Fórum Parlamentar da SADC, distintos convidados, caros parceiros de recurso. É para mim uma honra e um privilégio dirigirmos a esta magna Assembleia para deliberar sobre um assunto de importância crucial, que é a inserção entre governação, integridade empresarial e desenvolvimento econômico na nossa região. A Comunidade de Desenvolvimento da África Austral há muito tem está empenhada em promover a integração regional, a cooperação econômica e o desenvolvimento sustentável. No entanto, as nossas aspirações coletivas continuam vulneráveis, tornando-se um desafio generalizado e profundamente enraizado a corrupção. A corrupção, em todas as suas manifestações, corrói a confiança dos investidores, esgota os recursos públicos, aprofunda as desigualdades sociais e mina o Estado de Direito. Enfraquece a base da governação, impedindo o próprio desenvolvimento que pretendemos alcançar. Para que a nossa região prospere, temos que abordar de forma pragmática a corrupção a todos os níveis, nacional, regional e global. Embora os nossos respectivos governos tenham implementado políticas, leis e instituições para combater a corrupção, persistem ainda lacunas significativas. Estas lacunas permitem a existência de fluxos financeiros ilícitos, facilitam a dissimulação de receitas provenientes da corrupção através das fronteiras e permitem que criminosos de alto nível escapem à justiça. Precisamos de uma resposta mais abrangente, coordenada e robusta a este problema transacional. Neste contexto, devemos certamente refletir sobre a ideia de criar o Tribunal Internacional de Combate à Corrupção. O Tribunal Internacional de Combate à Corrupção, que está a ser proposto, foi concebido para tratar de grandes casos de corrupção que transcendem as fronteiras nacionais. Ao centrar-se na ação penal contra a corrupção de alto nível, o Tribunal ajudaria a pôr termo à impunidade dos funcionários corruptos e daqueles que os apoiam. O Tribunal Internacional de Combate à Corrupção está a ser concebido como um mecanismo complementar dos sistemas judiciais nacionais, intervindo nos casos em que as instituições nacionais não têm capacidade para responsabilizar os infratores. A proposta do Tribunal Internacional de Combate à Corrupção representa uma oportunidade única para a SADC e os seus Estados-membros reforçarem as estruturas de governação, aumentarem a confiança das empresas e criarem um clima de investimento mais previsível e transparente. A este respeito, os debates de hoje irão explorar a forma como o Fórum Parlamentar da SADC pode defender a adoção de um tratado para estabelecer o Tribunal Internacional de Combate à Corrupção e as necessárias ratificações do tratado nas legislaturas nacionais. Enquanto legisladores, temos uma responsabilidade fundamental na definição de políticas e quadros jurídicos que protejam as nossas economias e os nossos cidadãos dos efeitos corrosivos da corrupção. O nosso papel, enquanto deputados, inclui advocacia, pelo que é crucial que aprofundemos a nossa compreensão entre um Tribunal Internacional de Combate à Corrupção, do seu mandato e do seu potencial para capacitar os nossos quadros nacionais e regionais sobre o combate à corrupção. Outro papel ativo que podemos desempenhar é o de promover o apoio aos nossos governos e garantir a vontade política de acabar com a corrupção. O reforço da defesa regional confirma o nosso empenho em proteger a gestão das finanças e dos recursos públicos, o que deve estar em consonância com o objetivo mais amplo da integração da SADC. Temos de trabalhar em colaboração para integrar medidas anticorrupção nas políticas comerciais, industriais, financeiras e de investimento, a fim de garantir um ambiente empresarial sem corrupção. O envolvimento das partes interessadas no combate à corrupção exige uma abordagem multissetorial. Os governos, a sociedade civil, as empresas e as organizações regionais devem unir-se para apoiar mecanismos como o Tribunal Internacional de Combate à Corrupção. Esta comissão tem um papel importante a desempenhar na facilitação do diálogo e na criação de consensos entre as partes interessadas. Em conclusão, senhoras e senhores deputados, a corrupção continua a ser uma das ameaças mais prementes ao desenvolvimento sustentável da África Austral. Enfraquece a nossa soberania, ameaça a estabilidade econômica e põe em causa o Estado de Direito. Ao apoiar o Tribunal Internacional de Combate à Corrupção, damos um passo significativo para desmantelar as redes de corrupção e garantir que a integridade, a transparência e a justiça prevaleçam e continuem a ser as pedras angulares da governação na nossa região. Senhoras e senhores deputados, gostaria de vos exortar a participar nas deliberações de hoje com compromisso comum para a tomada de ação. O momento de agir é agora. As nossas populações, economias e gerações futuras dependem das nossas decisões de hoje. Agradeço pela vossa atenção e tenho aberto esse workshop. Muito obrigado.
Thank you so much, Honorable Chairperson, Honorable Mendes, for the opening remarks, which in a way is setting a tone for the meeting. At this point in time, let me now invite the resource persons for this meeting or workshop, and that they should now take over and facilitate the rest of the agenda items on the program. Over to you. I think the first part is an overview of the IAC code. Yeah, thank you so much, Madam. Over to you. Just a minute, our technicians, I don't know, the SG, I was acknowledging that she's online, but she has just called me that there is nothing that she's getting she has logged in, but there's nothing. So, Masanati, can you just confirm that we have sent her the right link? The link that she says there's nothing that she's getting. I told her the meeting is, yes. You are logged in. The same link that you shared with. All right. Maybe just call her just to confirm that, yeah. Okay, over to you.
Good morning, honourable members and distinguished guests. I stand on the protocol established at the beginning of this meeting. My name is Ruth Collefson. I'm from Good Governance Africa, and it's my honour this morning to introduce Justice Richard Goldstone, who's a retired Justice of the Constitutional Court of South Africa, to which he was appointed by Nelson Mandela in 1994. He is the former Chief Prosecutor of the United Nations International Criminal Tribunals for the former Yugoslavia and Rwanda. Justice Goldstone is Vice Chair of the Integrity Initiatives International, and he'll be taking us through an introduction to the court this morning. Thank you.
Good morning to you all, and thank you very much, Ruth, for your introduction, and thank you so much for inviting me to address this very important parliamentary, SADC parliamentary committee. It really is starting for the reasons given already to this meeting, that there isn't far greater urgency and action taken by parliaments and by lawmakers and by governments all around the world, because corruption at the highest level, at the level of head of state and high official level, is a disease which infects literally our whole world. It's really startling that as long ago as 12 years ago, in 2013, the then United Nations High Commissioner for Human Rights, Navi Pillay of South Africa, she said corruption kills. The money stolen through corruption every year is enough to feed the world's hungry 80 times over. Startling statistic. She added that corruption denies them their right to food, and in some cases their right to life. Since Navi Pillay said that 10 years ago, 12 years ago, the amounts lost to corruption have only risen, and risen sharply. So corruption, grand corruption, is a human rights issue. It must also be recognized that it contributes to climate change. There are kleptocrats in some dishonest governments that profit greatly from the illicit forestry trade. It's estimated to be worth in excess of $100 billion annually, and likely much more. The primary recipients of government climate-related development include countries that are perceived as being amongst the most corrupt in the world. Unless something significant is done to deter grand corruption, a large percentage of the billions of dollars in aid intended to diminish climate change will be misappropriated by kleptocrats and their collaborators. So we should recognize that grand corruption, kleptocracy, is also a climate change issue. It's also a refugee issue. The legions of refugees who are overwhelming countries in the Americas and Europe have been fleeing failed states ruled by kleptocrats. They include Syria, Venezuela, and South Sudan. Any initiative, any effort to alleviate the world's refugee crises must therefore also address a cause of forced migration. Again, grand corruption. The Pandora Papers, published in 2021, I'm sure many of you recall them. They were released by the International Consortium of Investigative Journalists, the ICIJ, provide additional compelling evidence that corrupt leaders throughout the world, aided and abetted by domestic and international accomplices, the banks, the lawyers, the real estate agents, finance providers, they enrich themselves at the expense of the health and welfare of their often desperate citizens. They secretly use the international banking system to move their substantial ill-gotten gains to foreign countries. The Pandora Papers exposed the secret finances and lavish lifestyles of more than 330 politicians, including 35 then current and former heads of state. I hasten to add that many of them do not relate to ill-gotten funds. related to secret funds. The Pandora Papers followed the ICIJ's Panama and Paradise Papers, which provided similar evidence of grand corruption. The name of Isabel dos Santos has come up again, not for the first time. She is the daughter of the late long-time president of Angola, José Eduardo dos Santos. The United Kingdom government statement issued only last month said that dos Santos had, I quote, systematically abused her position at state-run companies to embezzle at least £350 million, $442 million, depriving Angola of resources and funding for much-needed development. And that was probably the tip of the iceberg. In November, Foreign Secretary Lamy announced sanctions on dos Santos as part of a crackdown on dirty money and kleptocracy. Because grand corruption pollutes the international financial system and has other severe international consequences, it is not just a domestic problem for individual countries to address alone. Rather, it is a global problem that requires a global solution. Grand corruption, too, it must be recognized, does not exist because of a lack of anti-corruption laws. The great majority of the 186 UN member states that are party to UNCAC, the United Nations Convention Against Corruption, have enacted the required statutes criminalizing bribery, money laundering, and the misappropriation of national resources. However, some states that are party to UNCAC are governed by kleptocrats. They enjoy impunity in the countries they rule because they control the police, the prosecutors, and the courts. Some of those authorities, unfortunately, are often corrupt themselves. 48 members of the African Union have ratified the AU Convention on Preventing and Combating Corruption. There are other regional and sub-regional measures designed to prevent and combat corruption. The reality we should recognize is that kleptocrats and other dishonest high state officials will not permit honest, effective investigation of themselves or of their criminal collaborators. And we must not forget the criminal co-conspirators around the world. I've referred to some of them: the banks, the law firms, real estate agents, the other financial service providers who aid and abet kleptocrats in the transnational crime of money laundering. So that is the context in which there is a developing effort to establish the International Anti-Corruption Court, or for short, the IAC Court. Such a court would hold kleptocrats, the high state officials, and those who collude with them accountable where national authorities are unable or unwilling to do so. The scarce resources that will be available to this court will necessitate that its jurisdiction be principally directed at grand corruption or kleptocracy, the plunder and stealth of public assets by heads of state and other high officials, and importantly, those who collude with them and enable them, whether they come from the public or the private sector. The envisaged court would have jurisdiction over crimes of corruption committed by nationals of an IAC court member state and crimes committed in the territory of an IAC court member state. There is no need to invent any new crimes of corruption. We would rely on crimes already recognized by the 186 states that have ratified UNCAC. Those crimes have thus become truly internationalized. They are the bribery of public officials, embezzlement and other misappropriation of public funds, money laundering and obstruction of justice in relation to those offences. There are also some non-mandatory offences contained in UNCAC and that are being considered for inclusion in the draft statute for the court. These include trading in influence, illicit enrichment, and concealment and abuse of functions. The IAC court would be a court of last resort. I stress this. It means that it would acquire jurisdiction only in cases in which the appropriate domestic authorities are unable or unwilling to investigate or prosecute corruption. Member states would also be able to refer cases to the IAC court. It would be an institution able to offer what could be crucial assistance for example, to states that are willing to investigate and prosecute the corrupt, but do not have the resources or the expertise to do so on their own. The IAC Court's expert investigators and prosecutors could be called upon for assistance by prosecuting authorities in such countries. At least one such transitional country, Moldova, in Eastern Europe, has already endorsed the establishment of the IAC Court. Its personnel could work with nascent islands of integrity in such a country to help build its cases. That could include facilitating mutual legal assistance requests that are required to obtain evidence located in foreign jurisdictions. Kleptocrats will, of course, do all they can to oppose the establishment of the court. The last thing they would do is to allow their countries to join willingly. However, they have a crucial weakness, an Achilles heel, and that is their laundered illicit funds. For obvious reasons, few, if any, kleptocrats keep their ill-gotten gains at home. I've certainly never heard of one. It is too risky. They don't know how long they will be in power and what will happen to their illicit assets. So billions of dollars of stolen assets have been laundered in a number of countries. They include the United Arab Emirates, the Netherlands, Singapore, Switzerland, the United States, the United Kingdom and its overseas territories. There are a number of others. In some of the countries where laundered funds are held, if some of the countries where laundered funds are held would join the International Anti-Corruption Court, and several are considering doing so, then illicit assets could be identified and frozen by the court. Through orders of restitution, those funds could be repatriated at an appropriate time to the countries from which they were stolen. The kleptocrats would divert their funds to jurisdictions that have not joined the IAC Court. However, they will not have assurance that those countries will not sooner or later join the court. Their illicit laundered funds will not be as secure as they would have been without the court. If there is a high risk of those funds being misused if returned to the corrupted state, they could be repurposed for refugee and humanitarian purposes, or repatriated only at a time when they would reach the real victims, the millions in need of those countries and their forced diasporas. Integrity Initiatives International, of which I'm a vice chair, has just completed the first draft of a statute for the IACC. We have learned many lessons from former and existing international criminal courts, and especially the International Criminal Court. We have concluded, for example, that the IAC Court would not require a system of pre-trial chambers. In the case of the ICC, they have proved to be expensive and time-consuming. They were not a feature of other successful international criminal courts. In our draft statute, which will soon be available, we have made provision for a two-division court, a criminal division and an assets division. The criminal division would have jurisdiction over the kleptocrats and other high officials who have plundered their countries and those complicit with them, those who facilitate the plunder and the laundering of the stolen assets. It would also have authority to freeze and seize the laundered stolen assets and hold them until they can be returned to the real owners, the people of the countries who have been robbed. The civil division, the assets division, would also have jurisdiction to seize and freeze assets, so it wouldn't need a criminal proceeding to allow that to happen. But in addition, the assets division would resolve the inevitable disputes that are likely to arise with regard to identifying the laundered funds and determining their fate. It would also exercise the necessary control and management of the seized assets. Unlike the case with regard to other international criminal courts, the draft treaty would recognize juristic persons, corporations, as amenable to the jurisdiction of the court. This is regarded as crucial, having regard, for example, to the role played by corporations, and particularly multinational corporations, in the laundering of assets. Money launderers for many years have made use of shell companies to hide their ill-gotten gains. Other innovations in our draft statute relate to whistleblowers. In the first place, the treaty will prioritize protection for whistleblowers. They are the most important source of information with regard to corruption. They are also the most vulnerable. They're vulnerable to attacks on their very lives and those of their families. Unfortunately, we've learned this to our cost. Provision will be also made to remunerate whistleblowers who provide the court with original information not otherwise ascertainable. The operational cost of the IAC court would constitute a small fraction of the amount of illicit assets that it could seize and return to their originally intended purpose, the public good. In addition to orders of restitution, it could levy fines on those guilty, and those could be used to defray some of its costs. Our drafting committees have been fortunate to have as members leading experts on relevant international criminal law from around the world. Our meetings have been generally hosted by a German foundation, the New Institute Foundation in Hamburg, Germany. We've held 3 in-person meetings there. There are now over 300 leading figures from across the world, including more than 50 former presidents and prime ministers, and 32 Nobel laureates who have signed a declaration calling for the creation of the IACC. Let me add that our drafting committee has been well represented by Africa. African experts have joined us at our 3 meetings in Hamburg, and the African experts sit on virtually all of the subcommittees that are helping us and have helped us with advice for the treaty. This is really an opportunity at this initial stage of setting up the International Anti-Corruption Court, at this initial stage of drafting a statute, for Africa to place its imprimatur on the draft statute. Africa obviously has huge interest in the International Anti-Corruption Court, and it is crucially important for African governments and African experts to assist us with the drafting of the relevant statute for the court. To deal with where we are at present, Colombia was the first country to call for an IAC court back in 2016. More recently, the Netherlands, Canada, Nigeria, Moldova, and Ecuador have committed to working towards the creation of the court. Some months ago, the European Parliament passed a resolution calling for the IAC court. Additional countries from each region of the world have also expressed their interest in the idea. United Kingdom Labour Party, the present government in the United Kingdom, has, through its Foreign Minister David Lammy, expressed firm support for the court. In Africa, apart from Nigeria, there is strong interest from governments, including Senegal, Zambia, the Democratic Republic of the Congo, Rwanda, and Côte d'Ivoire. We are approaching others. The effort to create the court will take time, but the momentum generated in the past 3 years suggests that it may be possible sooner than even its strongest proponents think. The time is now to strengthen the proposal so that the eventual court can provide as meaningful as possible a check on corruption. The support of those of you in this audience today can play a crucial role in ensuring that the African voice and African support for the International Anti-Corruption Court is forthcoming in the coming months. I thank you for your attention.
Thank you, Justice Goldstone. With your permission, I'd like to open the floor for any questions with Mr. Manzi's permission. Any questions for Justice Goldstone? Okay, Justice Goldstone, thank you very much for your time. It doesn't seem as if there's any questions just yet, but I'm sure as the proceedings continue today, there may very well be some. Thank you very much for your time. Thank you.
Thank you very much.
And then with permission, can we break for tea? Oh, sorry, Justice Goldstone. There is a question.
Oui, merci beaucoup. Moi, c'est M. Setin. Je suis député national du Parlement de la République démocratique du Congo et professeur de droit public à l'Université de Kinshasa. La création d'une cour pouvant tenir compte de la corruption, c'est une bonne chose. Parce qu'au niveau des juridictions internes, il se pose un sérieux problème. Et la plupart des dirigeants, quand ils arrivent au pouvoir, ils sont protégés par leur pouvoir. Et lorsque on arrive à mettre la main sur un dignitaire du régime, on fait semblant de l'arrêter, et quelques jours après, il est libéré avec autant de millions partis. Je crois que la création d'une cour, elle est d'une importance capitale, mais créer des divisions, je crois qu'il faut en aller au-delà parce que, et comment on va faire en première instance au niveau de ces cours-là, et comment aussi aller en appel, parce qu'il s'agit d'une cour. Je crois qu'il faudrait voir la possibilité, parce que en première instance, c'est au niveau d'appel, comment ça va se faire. Je voudrais quand même avoir votre position là-dessus.
Right. Do you understand correctly the question? The sound wasn't wonderful, but is the question as to how an international anti-corruption court would arrest people indicted by it? Is that correct? Have I got the question correct, Ruth?
He's just having the translation.
Right. Well, you know, obviously, all international courts, and there's no exception. Every single international court in the world, whether they international or regional or sub-regional, or in fact domestic, all courts have to rely on governments to carry out their orders. Courts have no powers and have no police force, have no army of their own. So they're completely reliant on governments. And it's for that reason that these international agreements are entered into, where governments agree to comply with orders of courts to which there are parties. So we see the position with the International Criminal Court, for example. It issues arrest warrants, but it has great difficulty in executing those arrest warrants because the people against whom they are granted have the protection of the states from which they come. This is obviously a problem, but one never knows though. I remember when I was the chief prosecutor of the Yugoslavia tribunal, and we issued an arrest warrant against Radovan Karadzic, the head of the Republika Srpska in the former Yugoslavia. We issued an arrest warrant against the head of his army, Ratko Mladic, but they were protected by Serbia. It took 13 years, but they were eventually arrested and they came before the court. President Charles Taylor of Liberia was eventually arrested and appeared before the Sierra Leone court. So one never knows how long it will take. Milosevic himself, the president of Serbia, he thought he was safe in Serbia, but he wasn't. There was a revolution, he went out of power, and the president who took over from him put him onto a plane and sent him for trial in The Hague. So it's a matter of time. That's the one point. But the second, I would stress, one of the advantages of an international anti-corruption court, which is not open to an ordinary criminal court, is this power to seize assets. It's a hugely important power because it will act as a deterrent. It would be kleptocrats, it would be corruptors would know that their assets are going to be subject to be seized in a country to which they sent for laundering. It will make them pause and think a second and think a third time. And the many billions of assets, if not trillions of assets that have already been laundered, all become subject to search and seizure, even without the arrest the dishonest leader who sent those monies abroad. So this would be a huge additional power of an international anti-corruption court. But you're quite correct to point out the difficulty of making arrests of these people. But their time comes. Sooner or later, one doesn't know what the future holds for these people. And I don't think any reasonable person would enjoy having an arrest warrant out for them. They cannot travel safely. They don't know who's going to arrest them, when or where they're going to be arrested. So it's not a pleasant situation to be under an arrest warrant from any international criminal court. But thank you for the question.
Thank you, Justice Goldstone. Honourable Member, does that answer your question? Madam Chair?
Non, très bien, ça va, c'est bien.
Madam Chair?
Senhor Juiz, eu sou Ruth Mendes, de Angola, e de facto foi aqui referido o caso da Isabel dos Santos. Infelizmente não é o único caso. Ela provavelmente, por ser filha do presidente, ficou o caso mais destacado. Mas temos muitos mais casos. Eu sei que quando da saída do presidente Eduardo Santos do poder, o novo presidente levou como divisa a luta contra a corrupção. Nós sentimos, de facto, um grande desejo, inicialmente, de se avançar com essa luta, mas, infelizmente, nós continuamos com casos de corrupção. Essa é uma questão. A outra questão é todo o esforço que o governo tem feito para recuperar os ativos levados fora do país e que estão em bancos estrangeiros. Não se conseguiu ainda que grande parte desses ativos regressassem. Estamos a falar do valor que se pensa que esteja em bancos estrangeiros. Provavelmente cerca de 20% é que conseguimos que regressasse ao país. Me parece que, de facto, um tribunal dessa natureza poderá ajudar, sim, mas já respondeu parte da minha pergunta quando respondeu a questão do meu colega da RDC, mas, na verdade, é uma luta grande que nós temos tido para que esses recursos ilícitos, esses recursos saídos de Angola de forma ilícita possam voltar. Outro fenômeno que nós estamos a ter agora em Angola é a criação de fábricas ilegais de mineração de criptomoedas. Quase que por mês são apanhados várias fábricas em vários pontos do país, em Luanda, sobretudo, onde são mais casos de fábricas ilícitas de mineração de criptomoedas, lideradas por chineses. Cidadãos chineses se encontram em Angola, que entraram em Angola ao abrigo de alguns acordos que Angola, de financiamentos que Angola tem com a China e que, de facto, têm tirado o sono às autoridades angolanas. Portanto, me parece que um tribunal dessa natureza poderá ajudar, mas tudo vai depender da forma também como ele vai ser organizado e, como disse antes, apesar da vontade política, mas normalmente nós temos altos funcionários ligados a esses indivíduos e, portanto, nem sempre é fácil nós conseguirmos combater esses casos de corrupção. Muito obrigada.
Thank you very much for your important comments. Let me stress that an international anti-corruption court wouldn't be a panacea. It wouldn't solve all the problems of corruption, not by a long way. They're just too huge. It would be really just an additional, crucially important additional tool to fight corruption. Corruption really has to be fought at the local, at the domestic level. That's where the crimes take place. But what's missing at the moment, you've got many states with good anti-corruption laws. You've got many states with good anti-corruption laws that are simply not enforced. When in our own country in South Africa, during the Zuma years of state capture, we have very good anti-corruption laws, but they weren't enforced. The then government really made it almost impossible for the prosecuting authority to do its work. It was infected. It was taken over, and the police too were interfered with. So, but the laws are there, but they're not enforced. So the International Anti-Corruption Court really, its main use, its main need, is because of the international ramifications of this corruption at the highest level. It's the laundered monies. It's the illicit funds that are sent out. It's been estimated that more money goes out of Africa in illicit funds than comes in for foreign aid. I mean, South Africa is a net export of funds because of the illicit funds that are sent out. And it's for that reason that you need the International Anti-Corruption Court to work side by side with domestic authorities, to help domestic authorities, to act as a further level of getting to the people. But you're correct, we have to recognize that the main fight has to be fought at the local level. We have to fight at the local level, at the regional level, and at the international level.
Thank you, Justice Goldstone. Madam Chair, is that? Thank you. And then there was a question from the honourable member from Lesotho.
Thank you very much, Madam. And I wish to thank Justice for this important topic. My name is Pinky Manamulela. I come from the tiny country, the country called Lesotho. Lesotho is a small country that has been invaded, or it has a disease, as you say, Justice. And this disease has been going on for a very, very, very long time. The moment I saw this topic, I gave it a big yes. Why? Because our countries are impoverished. We don't have the resources. We don't have funding because of corruption. But it's even worse when you are a member of parliament, especially on the opposition, we complain, but nothing happens. Our leaders, once they get to power, they're untouchable. The police cannot, they're immune, and the courts cannot do anything. Maybe a few of them become prosecuted after they leave their position. So I strongly support the idea of the International Anti-Corruption Court. My question will be, Justice, tell me, in Africa, we have had a lot of aid from international aid. And some of this aid involves huge amounts of funding, which we think should have an impact in our countries. But you see, you hardly see the real impact. We even feel that sometimes this money comes in and then goes back somehow to its original country. How are you going to, how is the International Anti-Corruption Court going to deal with such an cases where we feel the money just comes in and then is diverted back to its original funder? Thank you.
Well, thank you for another interesting and important question. The example you give is precisely one needs the International Anti-Corruption Court. Let me say two things. Smaller countries like your own, like Lesotho, and there are many others, I refer to Moldova and Eastern Europe. The present president of Moldova has made it clear that she has gone to a lot of trouble with her prosecuting authorities to get evidence against her predecessor who was corrupt and who sent many illicit monies from Moldova overseas. But Moldova is a small country. It's got a population of about 2.5 million, I understand. It doesn't have the facilities. It doesn't have the experienced judges. It doesn't have the experienced investigators, the experienced prosecutors to put on trials in Moldova. And it is supporting the International Anti-Corruption Court for two reasons. Firstly, it feels that it's collected the evidence. A lot of the evidence is there, but they don't know what to do with the evidence. And there are two things. The first is that the courts of an International Anti-Corruption Court could be used to put these people on trial when they are arrested. And clearly they have to be arrested for this to happen. But secondly, the International Anti-Corruption Court would be able to supplement the work of the domestic investigators, of the domestic police, and assist them in their efforts. So it's smaller countries in particular that in my view will be the important users, important customers of an International Anti-Corruption Court. In the case you give of foreign assistance monies being repurposed by dishonest people and sent back overseas, that's exactly why you need an international court. You know, there is no international mechanism at all, anywhere in the world, that deals with money laundering, that deals with monies that are sent across border. And today with modern banking, it's the easiest thing in the world. It's a click of a few keys on a keyboard of a computer that can transfer billions of dollars across continents, across countries. So it's very easy to launder monies internationally today. And you need an international mechanism to deal with it, to help stop it. So I hope that begins to answer the question you have put.
Thank you,
Thank you.
Justice Goldstone.
Thank you very much, Justice.
Then we have a question online from the Secretary General.
Thank you. Thank you very much. Are you able to hear me?
We can hear you.
Yes, thank you very much, Prof. Let me also express my profound gratitude for the presentation that has surely given us a footing onto how we can expand on our processes at the SADC PF to continually assist members of parliament to engage on this particular issue. We have a model on public financial management, which actually somehow touches on issues of money laundering, as you have rightly pointed out. And we also have a tool that we have developed that really attempts to create a grasp around issues that you have raised this morning and making sure that the uniqueness of parliamentary engagement with citizens is actually accelerated. Now, I would like to ask you, from your perspective, do you believe that it would help if we surfaced, supposing at every plenary assembly, cases that are coming out or that are prominent in the region, and probably those that have gone beyond on corruption, with the hope that it would give members of parliament perspectives on how to navigate the separation of powers in relation to governance on this particular issue. Perhaps I'm stretching it a little bit, but given the principles and guidelines that we have, which we need to internalize and make sure that participatory processes are also ignited, that parliaments don't hide between being whipped into line. How would you think that the role of citizens in fighting against corruption and in surfacing some of these operations, in ensuring that there's openness and transparency and accountability as key barriers to prevent the surge of corruption can be ignited? And let me just end by saying I'm always reminded of Kofi Annan, where he rightly pointed out that if corruption is a disease, then transparency is an essential part of its treatment. So this is where I'm coming from, and I want to thank you for your great presentation. And I believe that members of parliament often do not look at case law, do not follow through to be able to raise awareness and ignite processes that can really better improve our transparency and accountability. Thank you so much for your presentation.
Thank you very much for your comments and in particular for the support you express for the International Anti-Corruption Court. You know, one can't generalize. I think one's got to look at every country separately. Every country has got its own particular concerns, its own particular laws, its own particular history, and countries vary. Some countries are fortunate to have honest leaders. Other countries are unfortunate in having dishonest leaders. And it's really a question of having the tools available to fight corruption. I stress again its importance that corruption is fought primarily at the domestic level. It's obviously the duty of the domestic, it's the huge responsibility of any government, of any police force, of any prosecuting authority, of any court system. It's their primary responsibility to fight corruption, to bring to justice those who are corrupt, and to recoup these huge assets that are out there. I mean, it amazes me that there aren't more efforts taken. In my own country, we're looking for a shortfall in the budget at the moment. The amount of the shortfall is really quite small in comparison to the huge amount of illicit funding that is out there in many other countries, of the world. So one can't generalize. The fight must be at the local level, but it's very important for the reasons I've mentioned that there should be this international mechanism that is available to assist the countries, in particular the smaller countries, but all countries, in this fight against corruption, and importantly in getting back these huge amount of assets that are literally every day being illegally sent out of our countries. I couldn't hear all of the question. There's a problem with the sound. If I haven't answered your question, please follow up.
Does that answer the question?
Thank you so much. I'll follow up. Yes, broadly, yes, because there's no specific answer to, I think I agree with the modeling around country processes. Thank you.
Thank you very much.
Thank you, ma'am. Thank you, Justice Goldstone. Any further questions from the members on the floor or online? Yes, honourable member from Eswatini.
Okay, thank you very much, Moderator. Michael Maslela, a member from Eswatini Parliament. I just want a small question to address the issue of how far will this IACC address the issue of implementing the issues of extradition orders involving corruption, maybe in a particular country, because you will find that a suspect, as soon as maybe he's alarmed for that, or as soon as he's got a warrant of arrest, he jumps to another country, and in that country is totally protected. So I just wanted to know how far will this help us in as far as that? I know we've got relevant issues that involve high-profile people that as soon as they are suspected, they jump to another country. Maybe for now, I'll just end there. I'll follow up with others.
The key to this court is getting sufficient relevant countries to join. When I say relevant countries, I mean obviously the countries that have suffered from corruption. The countries that are ruled by dishonest kleptocrats, oligarchs, those countries are not going to join at the moment. They're not going to join until those dishonest leaders have been put out of office, either for whatever reason. But the importance of the International Anti-Corruption Court is to get into its fold the countries where the monies end up, because that will give the court jurisdiction because of the presence of the monies in those countries. So it's my guess that we need at least about 30 countries, 25 to 30 countries, to join the International Anti-Corruption Court to get it up and running. As long as those countries include some of those, like the United Kingdom, maybe Switzerland, Singapore, other countries may be prepared to join, countries where the illicit funds ends up. You know, these governments aren't very happy about the money, the illegal money ending up in their countries. It doesn't do them any good. And this is why we see in the United Kingdom at the moment, huge steps are being taken to try and recover illicit assets, to find out who is behind these shell companies that own homes worth millions, many millions of pounds in the most expensive suburbs of London. It's not good for those governments that is happening. So I think it's important for those governments to join. There are many countries in Africa that are suffering from corruption. Countries with absolutely honest leadership, with honest governments, who have been unable to stop these illicit funds going out. An international anti-corruption court could help them. You know, we can't be going around with our heads in the clouds. We must recognize the problems, the difficulties. It's not easy to get your hands on the dishonest leaders themselves. They're protected as long as they stay in their own countries. But if they're brought before the court because of their illicit assets, that would serve them right and would certainly be a great weakness and a means of attacking at least some of the corruption.
Thank you. Honourable member from Lesotho.
So there are no more questions. No, I just wanted to say to thank him. Why? Because I had this opportunity to read about him, and I realized the amount of work he did internationally and then locally. So I think we are proud. Thank you, Honourable Justice. Thank you.
No, thank you very much indeed. I'm most grateful.
Thank you. Any further questions? Are we comfortable to close this session? So thank you, Justice Goldstone, for your overview that you provided today, and also for the clarification on the questions that have been asked by the honourable members. With everyone's permission, we'll now break for tea. If we could return sharply at 11 o'clock, please. Thank you very much.
One housekeeping issue. Our media and communication officer is inviting the honorable members for a group photograph before we take the tea. I think it will be taken outside the main entrance of the building. So perhaps we proceed for the group photograph before we take a cup of tea. I thank you.
Thank you very much for being back on time. The next session will be online, and I'd like to invite the participants to introduce themselves and to continue the next session. Thank you.
Good morning. Can you hear me?
We can hear you.
There is an echo that is coming. Anyway, Honorable Chairperson of the committee, Ruth Mendes, the Secretary General for SADC PF. I recognize also representatives of the Integrity Initiatives International, USESO and the Karam, but also representatives from Good Governance Africa, Robert and Deji, Judge Goldstone, who just made the last presentation, all other protocols observed. My name is Ipiana Msopole from the SADC Secretariat. Specifically, I'm from the Directorate called Organ on Politics, Defense and Security Cooperation. I've been joined by my two colleagues, Moteba from another directorate called Industrial Development and Trade, but also Acides from another directorate called Finance, Investments and Customs, purely because the issues that we have been requested to address cut across mainly three directorates. So we thank you for affording us this opportunity. SADC Parliamentary Forum were our partners, but now I think they are our brother or sister with the amendment to the treaty and the coming into the force of the amendment. So we also thank you for inviting us to be part of this important discussion. I followed the previous presentation with keenness because I remember a few years ago, there was this conversation about an international corruption court. And then I thought it had fizzled out. But I'm glad that, personally, I'm glad that it's still on. And we just wish you good luck. Because as I'll be mentioning also, corruption is a serious issue in our region. So we'll make presentations. They will not be too long presentations because my understanding is that there's going to be a discussion after these presentations. So unfortunately, I've still not been enabled to share the presentation. So in that case, I'll just proceed and start the presentation. It's not a presentation, it was a write-up which I had done, but later on understood that I needed to convert it into a presentation. So I still can just read from it and hope that you'll still be able to follow. So as a matter of introduction, I would like to explain that my focus will be on highlighting two key instruments or frameworks from the SADC organ perspective that address issues of corruption, but they also relate to issues of corruption as it relates to trade, industry, finance, and investment. I will not go through the instruments in detail. I'll just highlight issues in the instruments that I feel would be relevant to buttress the seriousness of the problem of corruption as it relates to trade, industry, finance, and investment. One of the instruments that I'll look at is the Protocol Against Corruption, which is generic in terms of how it was structured, but I will relate the important parts of this protocol and highlight those that I feel are relating to issues of trade, finance, and investment. But later on, I'll also highlight the strategic, the SADC strategy on the prevention and combating of transnational organized crime. And I will explain why I'm bringing this one in. It is also a very important framework which addresses also, speaks to trade, industry, finance, and investment as well. So the development of instruments at SADC level, just as in even in a country when they're developing laws, they're informed by challenges that have been seen. So the development of the protocol against corruption and also the strategy against transnational organized crime were informed by the seriousness of these two problems. So currently, what I would also explain as a matter of introduction is that the anti-corruption program at SADC level sits in the organ, as I've said, but it is anchored on the protocol against corruption. And it is being operationalized through a strategic anti-corruption action plan. Currently, we are implementing the second one, which is running from 2023, 2027. And this was also developed within the framework of the Regional Indicative Strategic Development Plan, RISDIP, which is running from 2020 to 2030. So the protocol was adopted in 2001, but it came into force in 2005 and currently has got 15 state parties out of the 16 SADC member states. And its objectives are mainly to promote and strengthen development by each state part of mechanisms that are required to prevent, detect, punish, and eradicate corruption. And I think this buttresses also what Judge Goldstone spoke about, that the issue of fighting corruption has to be done at the domestic level. So the protocol aims to ensure that there are mechanisms that are developed at domestic level, but also it aims to facilitate cooperation between member states to ensure that those measures are being effective, considering that corruption is a cross-border, can be cross-border. And this as well, I think, was alluded to in the earlier presentation, but also to develop and harmonize policies and domestic legislation. So apart from just having the mechanisms developed at domestic level to ensure that also at a regional level, these are harmonized. They are speaking to each other to ensure that at least there can be better cooperation in terms of addressing issues of corruption. So in terms of corruption and trade, investment, and finance, we know that generally in terms of trade, corruption increases transactional costs and creates barriers to market entry, as well as distorting market competition. But in industry, also corruption results in inefficiencies and hampers productivity. And then also when we talk about investment, it was earlier alluded to by the chair of the committee in our opening remarks that corruption erodes investor confidence. But in terms of finance, I can also highlight that there is a report that is produced by our colleagues in the police sector, specifically on the transnational organized crime. And the last one actually highlighted that 43% of all crimes that took place in the region were financial crimes. And these financial crimes included money laundering, illicit financial flows, fraud, scams, tax evasion, and terrorist financing. And having such a proportion of financial crimes taking place, it means it also affects financial markets, but also it means that member states are losing finances, and that also ties in with what Judge Goldstone earlier said, that these flows are now being stashed in the offshore accounts, leading to countries not benefiting, or leading to countries' fiscus being stretched, because part of the resources that were supposed to be allocated to development are lost through money laundering, through corruption, and other means. So the combined effect of corruption on trade, industry, finance is significant, and it hinders economic growth and development in the SADC region. Now, the relationship between the protocol as well as the trade, industry, and finance can be looked through a number of provisions in the protocol, starting from the preamble, where the protocol talks about adverse effects of corruption in economic foundations of society, in which case it broadly recognizes the inherent negative impact of corruption on trade, that it is actually affecting the economic foundations of member states. But also when you look at the definitions, which I will not go through, but only highlight that the scope of the protocol covers both public and private sectors. And by addressing these two, the protocol addresses corruption that can occur both on the government side, but also where, for instance, when we talk about trade, when we talk about industry, we talk of finance and investment, where there is an interface between government and the private sector. So we're talking of sections such as customs, procurement, and regulation of trade and other functions, which are very critical to member states. So it also covers aspects of commercial bribery, that is private sector corruption. And also, if you look also at talking about the same issues of definitions in the protocol, which covers issues of bribery, embezzlement, misappropriation, influence peddling, and commercial bribery, fraud, but also aspects of money laundering are alluded to in one of the definitions. These are things which facilitate illicit activities, which in turn impact on trade, industry, investment, and finance by, among other things, creating unfair advantages and increasing transaction costs, distorting markets, competition, as well as undermining fair trade practices. So the intention was to ensure that member states that are state parties to this protocol have legislation that criminalizes, or the scope captures these forms of acts, or what are called the acts of corruption, which can also impact, when we look at them from the perspective of trade, they can impact several aspects that relate to trade, finance, and investment, and thereby undermining fair trading practices and other issues. And they also enable illicit trade by distorting processes, and eventually this affects regional economic development. And then also I mentioned earlier on about the commercial bribery in the private sector, which can undermine decisions, regulatory decisions, but also end up creating legal uncertainty. and also reduce foreign investment. And also the issue of destabilizing financial systems, I alluded to also by giving the example that I earlier gave of the threat assessment that finds that most of the criminal activities that are taking place in the region, 43% of them are financial related, and I've highlighted them. So collectively, all these will hinder economic growth and create an unpredictable business environment in the region, which does not augur well with the region's ambition within SADC of advancing economic integration, but also ensuring that there is prosperity for all. In Article 4 of the protocol, where it highlights preventive measures which state parties are supposed to take, it includes some of them. I've just highlighted a few. Member states implementing government revenue collection and control systems that deter corruption. And when we talk about that, we are talking about corruption in customs, in tax collection, which actually eventually also impacts trade flows and cost as well. We earlier mentioned about the issues of transactional costs, but it also mentions about adopting deterrence to bribal of domestic officials and officials of foreign state. This also attaches on issues of cross-border trade, but also addressing the issues of payment of bribes to officials in other countries, which can also be undermining, especially to the area of trade. But also adopting of legislative and other measures to prevent and combat acts of corruption committed in the private sector, which reinforces efforts to clean up trade practices within businesses. And I think this is where we've also found that in most member states, their legislation, when it comes to criminalizing corruption in the private sector, still has there's still more that needs to be done. Much as we see that in other member states, they have upgraded their legislation to ensure that they have adequately penalized corruption in the private sector. And then also there is Article 6, which talks about acts of corruption relating to officials of foreign state, which directly addresses the forms of corruption that can undermine international and regional trade by giving unfair advantages to companies willing to pay bribes abroad. So in a nutshell, those are some of the provisions which, though generic, but they are actually relevant when we're considering the context of trade, finance, investment, in terms of how the impact that corruption can have in those areas. I will also, as I said earlier on, just touch on the SADC integrated strategy to prevent and combat transnational organized crime, which was approved in around 2022. This has also highlighted numerous ways in which transnational organized crime, which is enabled by factors such as corruption, poses a significant threat to legitimate trade in the region. By, among other things, exploiting trade infrastructure, engaging in various forms of illicit trade, and diverting resources away from economic development. Just to highlight some of the things, the strategy has emphatically stated that transnational organized crime is enabled by corruption. So that is why I also highlight this strategy as important, because behind the transnational organized crimes that have been identified, corruption is what is driving them. And it also highlights that corruption has infiltrated various levels of government, including police, customs, and other security agencies, making the fight against these crimes very challenging. These are now called embedded state actors. So they are actors on the side of government, which are supposed to regulate and ensure that there is free flow of trade between countries, between member states. But they themselves, because of corruption, have also become part of the problem. So that is where now the challenge also is, that is highlighted by the strategy. Of course, it calls for zero tolerance to corruption and measures against corrupt behavior. I'll briefly also just highlight in terms of its implementation. But ultimately, corruption impacts on trade by undermining rule of law. I think this was earlier also mentioned, especially at critical trade interfaces like customs and border crossings. That is where the rule of law gets undermined, and it also results in countries losing much needed revenue. And it's become even more imperative now with the sudden move away from the Western countries, moving away from donor funding, and in which case countries have to find their own resources to finance their activities, to ensure that they progress. But also, one thing that transnational organized crime does is to create parallel criminal economies which exist alongside the formal economy. And then in the process, billions of dollars are being lost. And this is also highlighted in the strategy. But it also recognizes that the operationalization, for instance, of the Africa Continental Free Trade Agreement, to which the last time I checked, most SADC member states have signed up to, whilst it is an opportunity, it also exposes as well the countries to security risks, including transnational and cross-border criminal syndicates and cartels that may want to exploit opportunities. So the potential influx of movement of people, goods across borders is also a challenge to law enforcement. So it's an issue of countries having to balance between the two, the security threats as well as ensuring that there is free trade. And it also actually demonstrates how corruption can actually undermine such kind of agreements that are meant to unlock trade, but also they become a potential opportunity for criminals to take advantage. Some of the categories of transnational organized crime that the strategy has highlighted includes the illicit markets, which I earlier on talked about. These are in drugs, but all of them fueled by corruption that is actually feeding, that is fueling for them to continue to happen alongside the formal trade that happens between member states. Contraband as well has been highlighted as another category of transnational. Illicit exploitation of natural resources. I recall the chair also mentioned about illegal mining that is taking place. You find that behind that, it is a transnational organized crime as well. And then illicit financial flows and money laundering, that these are financial crimes as well. And then also it highlights the what? Not that even the infrastructure that countries have created for formal trade to happen have become also conduits as well for what? For transnational organized crime to thrive, because they're utilized. And again, it goes back to the issue of the embedded state actors that become part of the problem. So to wind up, I would want also to mention that in terms of the implementation arrangements of the strategy, it is a multi-stakeholder process which involves the trade-related sectors. And that is where I also want to just highlight that the issues of anti-corruption, even at the regional level currently, due to its cross-cutting nature, there is now more of collaborative approach that is being adopted of working with sectors, because corruption exists maybe on its own, but it also enables a lot of other crimes, and therefore addressing it would require the involvement of sectors in which it is enabling crimes also to happen. So, for instance, the transnational organized crime, the trade-related sectors that are involved, but The strategy also mentions, and I just highlighted Parliament, and this Parliament can be both at the regional level but also at national levels. Currently, I need just to mention that there are processes already going in about 4 countries, Eswatini, Zimbabwe, South Africa, and one more, which I'm forgetting, in developing their own national, transnational organized crime strategies. And those are also multi-stakeholder processes. And of course, the extent, I think that is where also parliamentary involvement is important, especially considering that this is a national strategy. More countries will join the line because eventually this is a regional strategy which has to cascade down to the national level. The problem is at the domestic level, and the strategies have to be implemented at the domestic level. So in conclusion, I would again just highlight that I've just highlighted 2 mechanisms, the protocol against corruption, but also the strategy on transnational organized crime, which is enabled by corruption. These are from our perspective as the organ, but I would also want to leave my colleagues to highlight the issues on the part of trade, but also on the issues of, I think, customs. Thank you.
Thank you very much. If we could move on to the next presentation, please.
Hello, good morning. Hello, good morning. I don't know whether.
Good morning.
Good morning. My name is Alcides Monteiro. I'm the Senior Program Officer Customs at the SADC Secretariat. I'll take the comfort of the protocol already observed. I'll do a presentation on the customs issues and trade issues, those related to corruption, but also integrity, corruption, and some measures which are in place so that we can prevent corruption in this sector. I'm trying to share my presentation, but the indication that is saying that the host is not allowing multiple presenter sharing for this meeting. Being that the case, I will just go through the presentation without sharing it. Oh, I think I managed to put the presentation. I don't know whether you can see the presentation there. This is all in all, our presentation is more on integrity, but also touches corruption, because this goes hand to hand, the two, integrity and the corruptions. This is the language in SADC, or when we talk of, or SADC as a region, when we talk of corruption issues, or even the international instruments like those from World Customs Organizations. We talk more of integrity because encompassing all the aspects which is required as to tackle the issues of corruption. Those are the instruments which is this, as a SADC we use for the purpose of addressing the corruption, but also the issues of integrity. Apart from the treaty, we have the protocol on trade, but also we have the protocol on finance and investment. And our main plan is the Regional Indicative Strategic Development Plan. And as I was indicating, we also use the international instrument like WCO, Revised Kyoto Convention, which is Convention on Harmonization of Customs Procedures. And we have the WTO Trade Facilitation Agreement, SADC Trade Facilitation Program, SADC Coordinated Border Management Guidelines. We have a WCO Arusha Declaration. We have also Maputo Declaration, and we have SADC Code of Conduct for Customs Officials. The instruments which are presented there on the trade facilitation is there, first of all, is to facilitate trade. Because one of the issues which give chances for the customs officials and other border officials to be involved in corruption is when the procedures are very cumbersome. The cumbersome procedures give rooms for corruption, because the trader themselves, they want to see first their good to be cleared very fast. Second, if the taxes are too high, also they want to see reduce taxes, and therefore they are trying to find their way in order to see their goods to be cleared or to be evaluated or assessed as a low value good, and therefore to pay little taxes. But in customs and trade fraternity, the corruption is an issue, and it was recognized. And we use the World Bank language or definition of the corruption, which is centered on the abuse of public power for private gain. It's centered there. Customs officials and other border agencies officials, they have the powers. Those powers they can use for the goods to be cleared or not to be cleared. And therefore, they can easily be involved in corruption activities. But when we talk about corruption activities, we have to look at also the legal and the regulatory framework. This is in customs, especially. Legal and institutional framework, we have to put legal laws which allow easily clearance of the goods, all the processing, even from licensing up to the clearance at the borders. And also the regulations should be more simpler and clear. The institutional framework, most of the customs administrations, or I think all the customs administrations now, falls under the revenue authority. And under the revenue authority, we have the units. They can, in some countries, they call it the loss control, internal control units, which deals with the issues of integrity and also issues of corruption. And the other administration, they have the anti-corruption unit. And also there is the investigation units, which they investigate all spectrums of society, clearance, and also at times they find the officials and traders who are involved in corruption activities, and they profile those things. And also, when we talk of institutional framework, we have the roles of HR, where the HR have to implement the policy of rotations of the officers. You don't leave the officer at the border to stay there for more than 2 years. For the end of the day, there will be none. And you have also to make sure that the officers are trained in various subjects so that to enable them to perform their work properly. But the issues of rotation sometimes is controversial. There's this where the team leader in one of the border posts in the region, he got information from the trader themselves to say that you will be moved to another station. He asked, how do you know? He said, no, you will be moved in 2 weeks' time. And it happened in 2 weeks' time, he was moved to another station. There was rotation. Therefore, meaning that it is not only that corruption at the operational level there at the border, but also even at the management level. If someone at the border knows from trader that there will be rotation, meaning that there is information is coming from somewhere at the management there, or even at the HR, and therefore they have to look at the institutional issues. The procedures, I was saying that we have all those instruments which I mentioned. We have the Vice Security Convention, which is WCO, International Convention on the Harmonization of Customs Procedure. We have the WTO Trade Facilitation Agreement, and we have the SADC Trade Facilitation Program, and also we have coordinated border management. Those instruments is there to facilitate the trade. When the trade is facilitated, when you have the clearance, you don't take time to clear the goods. There does no need most of the time for the trader to find their way out of clearing the goods, because everything is facilitated. But also the information need to be available, because at the time the trader want contact customs authority because they have no information how much this good is for the clearance, what are the procedure, how long it take, the information is not available. And that creates conducive environment for the corruption activities to happen. But one have to understand that at the border, there are various border agencies operating there, not only customs, but there are other border agencies who operate. They perform their mandate. We have the customs, we have immigration, we have environment, we have the sanitary and phytosanitary, we have the police, state security, port health, and the list of the border agencies can be longer than
I'm sorry, but your network is breaking up a little bit. We're battling to hear you. Can you hear me? Your network is breaking up. Asenati, what would you like us to do? Okay, we're just sending him a message. One moment, we're just trying to get hold of him. One sec.
So I'm having a challenge with my connection here. Maybe I'll ask my colleague to continue with the presentation, because I see this might happen to continue to have these challenges. Ma'am Teba, can you go through the presentation, and maybe I will attend the panel discussion.
Thank you. Thank you. Please continue.
Yes. I was saying that the issues of HR, the procedures, when the procedures are very cumbersome, it gives rooms for the traders to find their way out. And therefore, there's a need to use all those instruments from WCO, which I have indicated. That is the Revised Security Convention, which is instrument is the convention for the harmonizations of customs procedure. We have the WTO agreement on trade facilitation. We have the STADC trade facilitation program, and we have the coordinated border management guidelines. Those enable the border agencies, the guideline in this case, enable the border agencies to work, to operate in coordinated manner. And of course, it reduces the chances of the border agencies to be involved in corruption because they do the clearance procedures at the same time. And nowadays, member states are implementing the single window, although not all the member states, but that is the recommended procedure, even under the WTO, to have a single window, which is an electronic platform where the goods are processed through that platform, and there's element of traceability. Whoever started to see the goods to act on particular consignment, and all the border agencies can see who have acted, and that reduces also the chances of corruption. Training is very important because the border agencies, they need to know at least what each other mandate is, what is the role of other border agents, at least to know it helps them also to reduce corruption. And the equipment is very important to share the same equipment for the borders or operation. In the STADC coordinated border management guideline, which I was mentioned, talks of cross the state borders illegally, fraudulent, obtain a visa, traffic in human being, smuggle of person, goods, weapons, or drugs are all activities facilitated through corruption. There's a recognition that all this, but if you look at all this visa, for instance, is immigration, who does a visa, smuggle human persons, immigration is involved, but customs is also involved, goods, weapons, meaning that to address the corruption on trade, we have to look at all the border agencies collectively, not only customs. Although customs is the notorious one when we talk of border crossing, but we have also to deal with all the border agents collectively. That's why our coordinated border management guidelines talks about all the borders, how to address this. And the modernization which I was indicating is very critical modernizations, because we have to have a single window, electronic single window, where there's traceability and where you can even audit the activities by each of border agencies. And we have to have a simplification of procedures. We have to have now in the recognition of small traders, we have to have a simplified trade regime, which is the simplified trade regime is for the small traders or for the human empowerment. But because some border agencies, customs, they take advantage of these small traders or human. Some of them, unfortunately, are illiterate, and therefore they prefer to pay bribes when they were not supposed to, and they were supposed to clear their goods easily without to pay them. The issues of 12, the trade information portal is critical so that it creates stability for all the traders to know what to have all the information, what is the taxes. Even some of them, they can do pre-clearance, and also can they do a consultation on their tariffs before they go to the border. Tariffs on the requirement for clearance of the goods. This also help them to do this. Other aspect of corruption is the licensing. The licensing also is when you to get a license for trading, or even the issuance of certificate of origin for any particular consignment. It takes time. It gives them chances for corruption. Normally, goods which are more targeted by the traders, or which are more object of corruptions, are the alcohol, tobacco, jewelries, those and precious stone, because those normally you have to pay, apart from taxes, normally duty, the custom duty, you have to pay excise duty. And most of these products are on demand. And being on demand, then is where the more activities on corruptions happen. There's all of customs in the region, and together with the other enforcement, border enforcement, they have to enforce also this anti-money laundering, because it is a critical, is a where to have this money laundering is done through the corruption activities, in which some customs and the other border agencies, they connive. For this, in recognition for all this, which is not only in SADC, but happening all over the customs, there is corruption in customs, paternity and paternity. SADC has developed the code of conduct for customs officials, where the key issues in this code of conduct is integrity, professionalism, fairness, and the equity, courtesy, transparency, and the conflict of interest, and the gift, acceptance of gift, official information, public comment, and disciplinary action. Gift, in some countries, they say the customs officials, they shouldn't receive any gift at all. Some of them, they accept amount, just low amount. Others, they will accept, but you have to present to the management. They have to report to the management when you get a gift. Meaning that this instrument, the code of conduct, have to be domesticated into the national laws or procedures of all the member states, so that to tackle the corruption. As I indicated as well, international best practice and some of the instruments which we use in SADC, we have the so-called revised Arusha Declaration, and which is the initial was Maputo Declarations, which talks of leadership and commitment, regulatory framework, transparency, automation, which automation is a key nowadays, because it reduces the contact of a human being at the border. You do your things from where you are processing, and the contact between the people or with trader and the border officials or customs officials is minimal, and it reduces also the corruption. And the reform and modernization, the issues of audit and investigation, because the customs officials or other border, they know that whatever they do today, tomorrow they'll be found because of the audit and the investigation. They have to enforce the code of conduct at national level for border agencies, in particular for the customs. And there's issues of human resources management. Human resources, as I indicated, this is controversial. At the time you find a team, the corruption itself is institutionalized in one team. That's why when you do the rotation, you have to split all that teams and bring other teams made with different officials so that to avoid them to be involved or to be more close to the trader in that particular border or customs station. The relationship between the border agencies and private sector should be monitored so that in order not to give more being closed and give that rooms for corruption. This, all what I have indicated can possibly impact the of corruption on trading. Although there does no clear study on the impact of corruption in trade in SADC, but of course it is well known. That's why the instrument which I was presenting are meant to address all these issues, because we know that the increased cost of doing business, corruption, it decreases foreign investment, thereby reducing economic growth, because the investor reduce the investor confidence in coming to this particular region, which is SADC. And also it hampers trade facilitation initiatives such as the customs and the reforms, which are essential in improving trade and reducing delays. I have to say that there is resistance most of the time when we are introducing reforms in modernizing the customs, because they know that what this modernization will entail will give now will stop them or reduce the opportunities them to be involved in corruption. That's why there's these issues of resistance, and at times you find some border officials, even if they have a master degree, they hide the certificate of master degree or those degree so that not to be promoted. Because when they be promoted, they know that they are going to headquarters and they will no longer be at the border, and they will not have the chances to get that benefits which they are getting from the corruption. With this, I submit. Thank you. Although I didn't share my video because my connection is not good for me to open my video. Thank you.
Thank you very much for your presentations. I'd like to open the floor if there are any questions from the honourable members for the two presentations. Please go ahead with your question.
Yes, my question, well, my name's Dumelang Saleshando from Botswana. My question mainly relates to the first one. The first presentation on the protocol against corruption. Is the list easily accessible of countries that have adopted the protocol? Or yes, adopted, I think is a correct word. I'm using the word loosely, not legally. And I've taken steps to make sure that their policies and domestic laws comply, and which ones are those and which ones have not adopted, because one of the duties for us as members of parliament would be to try and at least make the right inquiries as to why the executive may not be willing to make the necessary ratifications. And then the second one is, whilst we maintain that corruption is best fought effectively at the domestic level, I think we also need to make note of the fact that it is when regions become more vigilant in making sure that flows of illicitly acquired funds is much, much more difficult within a region, within a continent, and globally. What steps really have we taken as SADC at that level, at a global level, to put in place robust, effective measures that try to make sure that any funds acquired in an illegal manner will be difficult to deploy to any part of the region.
Thank you. The questions are posed to the first presenter.
Thank you very much for those two excellent questions. The list of countries, we call them member states, that have ratified, I'm sure on the website they should be, but as I mentioned, 15 out of the 16 SADC member states have ratified. The only country that is yet to ratify is Comoros, Union of Comoros. The last two to ratify were Madagascar and the Seychelles. So we are at 15. So now in terms of the next step of saying, okay, they have ratified, but what about their policies, their laws? Are they compliant with what the protocol is saying? What the mechanisms that have been established to track the extent to which the member states are complying with the provisions of the protocol. We have been doing what we call assessments. We did the first one in 2019, but it wasn't as comprehensive as it was supposed to be. So we only looked at a few of the provisions. But this year we have done another assessment, and I'm happy to mention that so far we have received submissions from 14 member states. They're still coming because as I said, the implementation of the protocol is overseen by a committee which was established under Article 11 of the amended protocol. The protocol was amended in 2016 to provide for the establishment of a SADC anti-corruption committee to oversee the implementation of the protocol. And as I said, there's a strategic action plan which operationalizes the 4 objectives of the protocol. So there are actions under each objective to try to translate the protocol into action. So there is that process that we do. I cannot mention the results of that assessment because it's yet to be submitted to the SADC Anti-Corruption Committee, and then it will go up to the ministerial committee of the organ where the SADC Anti-Corruption Committee reports. But I also need to hasten to say there is another more long-term mechanism that is being implemented, that has been developed, and it has been piloted as a way of doing a much more comprehensive analysis of the extent to which the member states are complying with the provisions of the protocol. Apart from that, you mentioned the issue of what extent are the countries in the region cooperating to ensure that the resources from one country do not go to another member state. That can be looked at 2 levels because also we know resources can come from one country in this region and go to another country that is not a member of SADC. So those can be looked at 2 levels. There is the United Nations level also. We know, I think it's been mentioned earlier, the United Nations Convention Against Corruption. There is UNODC, which we work with, that are the custodians of the UNCAC. This issue of cooperation is one of the issues that has been raised as a challenge amongst member states within the region, and there are efforts that are being undertaken to remove the bottlenecks, because there was a study that was done to see, because when we talk about cooperation, within the protocol, there is provisions for cooperation, but there is also another protocol called the Protocol on Mutual Legal Assistance, which also includes corruption as an area where member states should cooperate in terms of sharing of information, but also when it comes to matters of prosecution. So there is cooperation that is going on. Apart from that, there is also bilateral cooperation. There are member states within the region that have signed bilateral arrangements. I think there have been even cases where have been published in the media where, for instance, I remember one of the key cases that I can cite is where I think money was stolen from Lesotho and deposited in South Africa. But the Lesotho authorities and the South African authorities worked together. And there was, I think, a report in the media of a check being handed by South Africa to Lesotho of that money, which was frozen in South Africa, and through the legal processes was repatriated back. So there is some cooperation, but there is a recognition that it should be better. And a study that was done, as I've said, identified what the gaps were. And there were revisions that were done to the Protocol on Mutual Legal Assistance, but this is still an ongoing issue. And maybe one other issue which I can mention, which might also be of interest to members of to you, is the issue that most of the areas where the gaps still are in terms of legislation is protection of whistleblowers. That one is still an issue which there is more that is needed to be done in terms of member states having comprehensive legislation that addresses issues of whistleblower protection. Of course, a few member states, and I can mention here Botswana has legislation, but also you find that they've been challenges in terms of implementing it, because protection of whistleblowers is not an issue, but those are the areas where the technical support is being provided to ensure that the legislation is implemented. So there is that one. There's an area of access to information. I think the Secretary General earlier on in her question and comment mentioned the issue of transparency. One of the tools that can promote transparency is access to information. We still find that even from the last assessment, there's still a lot that needs to be done to ensure that the laws on access to information are there, but also they are robust enough to ensure that there is, and I praise, I think, SADC PF, because you hold your session, but you also make them public as part of the efforts to be transparent. So there are those areas, but there are more, because there are also areas of assets, recovery of assets, which I think they are more bordering on capacity challenges within member states, but also it is bogged down by the issue of cooperation, not just regionally, but mainly international. There are certain countries which is difficult to cooperate with, where these resources, where these assets are stored. So those are just some of the issues. But what we're also trying to do is that once the assessment is done, we can also look at specific issues and see how much has the legislation in those areas, even if member states can say we have legislation on this and that, how much is that legislation harmonized? Because harmonization of legislation enhances the capacity of member states to be able to cooperate. So that is, those are my comments or responses to the questions that were raised.
Thank you. Does that answer your question, Honourable Member? Thank you. Any other questions from the floor for both presentations? Yes, Honourable Member from Eswatini.
Thank you, Madam Moderator. I think
in the likes of the model laws that have been enacted before, including the financial, the public financial management, maybe also on the gender, the other one on the model law on the gender-based violence. Also this one will see a light, probably. That is how I look at it. Why? Because when you're looking at every nation, corruption is cutting across. Every nation is complaining, especially in my country, in Swaziland, where I'm coming from. It's a day-to-day problem. So I guess it will depend how fast the facilitators are on this one to make sure this legislative is put in place. But also to Monterrey, I think he spoke about on the Arusha and Maputo declaration. There is the issue of audit and investigation. I just want to know, in extension to the lifestyle audit, how far will this legislative maybe help us in terms of the lifestyle audits is concerned? Because I know some investigations, they just go a little bit broader, but at the same time, you will find I've got some assets that I've gained out of using the public power. That is what I've seen in Eswatini. It has been difficult on audit lifestyle. So because we've got our cousins, we've got who so and so, we take assets, we reach them, their names and stuff. So that's why I'm asking, how far will this one help us? And secondly, he spoke about the private sector. I just want to know, in maybe their consultations, what is the relationship between government agencies that are trying to fight corruption with the private sector? Because I would testify, in the private sector, corruption is so much alarming. So much alarming. I want to know what the relationship is. The public sector actually involved in this one, because they are killing our countries. Thank you, Moderator.
Thank you. Questions to the second presenter. Thank you.
Thank you, Honorable. On the issues which you have posed the questions, I will start by the first, where you have asked about the audit. To what extent the audit will help in terms of the lifestyles of the officers in these border agencies, in particular the customs. The objective of the audit is to surface everything and to have the information about the clearance of the goods, the procedures which were implemented, whether the procedures are correct procedures or intentionally there were procedures which were not followed, so that to get benefits. Normally, customs administrations, they have to declare their assets, I think regularly. Some of the administration, you have to declare your assets twice per year, and that also helps for the management to control even the right units at the revenue authority to control the officers, whether the officers are living within the ranges of their benefits, or they are living with additional benefits, resources, or which are not declared. the audit bring all these aspects of who is involved in what, how the procedure was followed, even the taxes implemented, because the time you find the officers are not implementing the right taxes for their own benefits, they are not following the procedures, and you see they present their lifestyle is not according to what they get as benefits, as their salaries, whatever. They are presenting different lifestyles. This is why the audit time to time, even you can have 2 years after you were a manager, station manager in one particular border post or custom station, they can see while you were performing the duty of task manager or border managers or you team leaders, you did this and that. Then they will bring you to the investigation. That's why audit and the investigation in customs administration, they work hand to hand. The audit present their reports to the investigation where they find there are some issues which need clarification, then it is submitted to the investigations for the investigation to find out what are the issues. And also the lifestyle is assessed. I remember in some customs administration, there are the managers, they were not using the uniform, but then because of that, they were even driving top range cars, and there was a decision to say everyone in the management have to use the uniform so that them to be exposed, those who are involved in or are having the lifestyle different from what they could have if they were using their financial. When it comes to the relations, on the secondly, the relation public and private sector, that relationship is very important because the private sector end up to know what all the information, and also where they can present the issues which they wanted the procedure to be, the tax to be, their complaints that make them to give a little room for the officers to be involved. This relationship between customs and the private sector is one of the recommendations from the WTO. Even also is one of the recommendations from the WCO World Customs Organization, because they make the customs not to be working on using the traditional approach where there was gatekeeper, but now it's more trade facilitators, and the private sector can expose an officer who are involved in the in corruption activity when it is they feel like it is not the right procedure, because that even the private sector end up to know the procedure right as the customs officials, as the other border officials, they know the procedures. That's why that relationship, which in SADC we have already established customs to business forum, which they meet regularly, the private sector and the business to discuss their issues, and the business to propose even procedures which can facilitate more of them. When there's a new law, before the law be there, then the private sector is consulted, and the private sector they have say on whatever these customs is doing and the other border agencies is doing. That is the response to your question, Honorable. Thank you.
Can I also come in to comment on the two issues, because they also touch on the corruption side of things. On the lifestyle audit, I think this is an issue that is gaining a lot of currency in a number of countries. I'm aware that at the legislative level, some member states have got declaration of assets legislation, which should provide the framework, but it's got its own challenges as well in terms of enforcement in a number of member states where if there is no, for instance, compliance, but also the other issue that has been raised is how the bodies that have been established to oversee these declarations, whether they have capacity to verify, because there is a declaration made and there has to be verification. But within this debate, I think in recent years, there's been this lifestyle audit that has come. I think it's important, but it is still, I don't think it is still something that it's been, there is sufficient legislation in most member states. The other issue that you raised about the relationship between public and private, when it comes to addressing issues of corruption, what is more critical for member states is to have national anti-corruption strategies that identify stakeholders, because now the fight against corruption is multi-stakeholder. And the private sector is one of the important stakeholders to be involved. We annually also track efforts that member states are making to engage private sector in addressing issues of corruption, because the protocol itself, as I earlier said, does not just look at the public sector, it also looks at the private sector. So in addressing issues of corruption, private sector has to be involved. So we look at the public-private partnerships as well as initiatives that are being undertaken to ensure that private sector is involved. But I think maybe from parliamentary perspective, it is maybe an issue of whether the old member states have got national strategies, because without a national strategy, it is difficult to engage private sector, because we need the strategy will clearly define what is the role of private sector when it comes to fighting. But I also do appreciate your views that private sector also, there is a positive side of it, but there is also a negative side of it. But when it comes to addressing issues of corruption, you have to deal with them in a way, because you just cannot engage, you cannot just address it without their engagement. So I just wanted also to add comments on those two, on the lifestyle as well as on the relationship between public and private sector.
Madam Chair, if you could continue with your question, please.
Eu comecei a intervenção agradecendo as duas preleções que nos conseguiram apresentar aquilo que existe em termos, aquilo que os casos, aquilo que são os casos de corrupção nos nossos Estados-membros, mas também nos apresentaram alguns instrumentos que ajudam na luta contra a corrupção. Em todo caso, eu venho de Angola, onde muitos aqui devem saber, é um país que de facto está a lutar contra a corrupção. E não obstante a adesão a esses acordos e a esses instrumentos, não obstante a produção de leis que vão no sentido da luta contra a corrupção, nós continuamos a ter ainda muitos casos. Recentemente tivemos o grande caso que foi divulgado, não é segredo, dos funcionários da Administração Geral Tributária que conseguiram desviar dos quadros dos cofres do Estado cerca de 30 mil milhões de dólares. Portanto, é um caso sério, Estão envolvidos altos funcionários da administração, administradores e diretores da Administração Geral Tributária. E o que eu devo dizer aqui é que, de facto, se a nível da SADC nós começamos agora ou temos agora a intenção de sermos mais enérgicos e mais duros com os casos de corrupção, de facto nós devemos ir nessa direção, porque o que acontece em Angola, e acredito que noutros países, é de facto muito grave, muito grave. Nós temos pessoas a viverem no limiar da pobreza. Nós temos crianças desnutridas, nós temos. O país está parado porque nenhum investidor sério aceita ir investir em Angola. E quando o fazem é sempre na esperança de que as coisas vão melhorar, a corrupção vai deixar de existir, vai reduzir pelo menos. Portanto, me parece que estamos a lançar a semente ou estamos a ressemear aquilo que já semeamos, que é a luta contra a corrupção, mas devemos, antes de mais, ser enérgicos e, como foi bem dito aqui, a luta deve começar nos nossos países internamente, mas também deve haver a cooperação entre os países da SADC para acabarmos com este mal que enferma as nossas sociedades. Portanto, era mais um comentário que eu gostaria de fazer. Fiquei claro em relação às apresentações que foram aqui feitas e penso que nós devemos, de facto, ir na linha de lutarmos contra este mal que afeta as nossas sociedades. Muito obrigada.
Thank you. The response from the online presenters.
On my part, I want to take what the chairperson has said as comments, but also just to highlight that Angola is one of the member states that we are closely cooperating with, and from what they submit annually, just like other member states, I have a picture of what is going on in terms of the volumes that you're mentioning. But also I noticed from Angola, there is huge volumes of asset seizures that take place, which actually also shows that there's a challenge, but there is also effort that is being made. So, Madam, it's just to appreciate the support that we get from Angola and the cooperation that we get from Angola, as well as the other member states in the room, So we're grateful. And as you have said, it's an ongoing fight. It's because the push factors are always there. And at this time when we're going through economic challenges of various types, the efforts will need to be doubled because the push factors are becoming stronger, and therefore the effort also has to be strong. And we would always value the contribution that Parliament can make. We recognize that perhaps our linkages maybe with Parliament will need to be strengthened, because even at the regional level, we need to work with other partners that are critical to also complementing where we need to be complemented in terms of the working with member states to ensure that the efforts are being strengthened to respond to the serious challenges that we raised here. But we appreciate the cooperation and the support.
Thank you. Any other questions from the honourable members for the presenters online? Are we comfortable to move on to the next presentation? If so, I would like to invite my colleague, Pusetso Morapedi, who's the African Coordinator for Integrity Initiatives International, to come and help us align what's been discussed now within the framework of the court. Thank you.
All right. Good afternoon, honorable members. Allow me to write on the protocols already observed this morning. So mine is really to, I guess, to sell some more. The selling of the idea was well done by our Justice Richard Goldstone this morning, of what the court is, what its objectives will be, or what they are, and how it may be of benefit, not just to Africa, but to the world. Our chairperson in the morning, when the case of Dos Santos was given, the case study, she mentioned that there are many stories and many examples, and she's right. And we do have a policy brief that was written on the International Anti-Corruption Court and how it can serve Africa. We will share the link with all of you. The policy brief really simplifies the story and the need for the court. It's not too technical, but technical enough for the legal minds to understand what we're trying to really sell as a campaign for establishing the International Anti-Corruption Court. And in that brief, we also have more stories, more case studies from Kenya, from Zambia, South Africa, Angola, and many others that really buttress why we may need a supra-regional body, such as the International Anti-Corruption Court, that may help, in a way, distance our leaders, from trying to prosecute cases that sometimes they also become accused of witch hunts and trying to go after former political leaders and now opposition leaders after losing elections. So I think, as we embark on our journey selling the idea of the court and really advocating for the court with our governments, which is what we're asking today, that we engage with the initiative and speak on our behalf in rooms where we are not in attendance, with your governments, with your party members, with civil society organizations, with the judiciary, in support of the court. It's because it is also an instrument, it will be a tool that will really help those who want to fight corruption at the national level, but they are unable to. Unable because maybe the institutions are unwilling, sometimes unable because of lack of capacity. And one may say, but what about regional frameworks? What about regional organs like, say, the SADC Tribunal? I think the SADC Tribunal also gives us a perfect example of why maybe another layer of accountability may be necessary, may be needed. Looking at what happened to the SADC Tribunal, we are looking forward to having the SADC Tribunal back in whatever form, it's for the people of Southern Africa. But if we look at how sometimes political interference plays a huge role in how corruption cases, especially grand corruption cases, cannot be prosecuted, bless you, cannot be prosecuted, and how maybe even regional bodies or tribunals cannot also prosecute such cases at the regional level. Maybe an impartial, neutral tribunal or court at the international level may help. And some may argue and say, but what about the Malabo Protocol? The Malabo Protocol, which is meant to expand the mandate of the African Court on Human Rights and People's Rights. I think it was tabled in 2014. And since then, only one country, I believe Angola, has ratified that protocol. So we're still waiting for more African Union member states to ratify the Malabo Protocol, which expanded that mandate of the court to include other crimes such as corruption. So if the Malabo Protocol is not being ratified, and now it's been, 11 years? It may take another 11 years for 2 more countries maybe to ratify. It may not, but let's just say the wind of change may come in Africa, and we have 14 more countries ratifying, or even 30 more countries ratifying for it to be, to come into enforcement. It doesn't also take away what can happen having an international court and also a continental court, such as the African Court. So what we are proposing is to have a regional court or regional courts, even specialized national anti-corruption courts, because some other African countries do have those specialized courts, working in complementarity with the International Anti-Corruption Court, especially where it is really difficult to prosecute some of these grand corruption cases. Some people have argued that when some of the assets are actually returned, they go back to the corrupt systems. What happens in cases like that? And the International Anti-Corruption Court proposes an asset division or an asset chamber that will deal with asset recovery or asset returns. Something that I believe is not in the statute of the Malabo Protocol or even some of the specialized courts that we have, the anti-corruption courts that we have. Some people have argued and said, but what about the ICC? What about the International Criminal Court? The ICC does not address corruption, and it will take about 2/3 majority of its member states to ratify for an amendment to the Rome Statutes to actually take effect. And we know how long that process can be. So to cut the red tape and the long journey to the amending the Rome Statutes, that's why we're proposing the International Anti-Corruption Court. And we're not saying it will take away the effectiveness, if there is any, or the efficiency, if there is any, of national courts or even regional courts. But we already know and we already experience how those are limited in their efficiency, in their effectiveness, mainly because of lack of ratifications, lack of enforcement, lack of accountability, because it is difficult to fight corruption. We always ask when we do civic education in Botswana, we always ask young people that we engage with, would you take your cousin, your brother, your friend to jail, to prison for corruption? And it's interesting how they respond. Of course, they respond jokingly sometimes saying, yes, we would. Some say, actually, we can't. It is that difficult to also, as a leader, to try and put someone in prison for grand corruption, especially if you've just won elections. You will be accused of, punishing or going after former leaders. If you are going after a sitting president, it becomes difficult. The Malabo Protocol, one of the limitations it has is that it offers immunity to sitting presidents or some high senior officials. But the IAC court actually seeks to do away with lots of immunities that most of our leaders would actually get with some of our regional provisions or instruments provisions. The issue of capacity, financial especially, expanding the jurisdiction of the African Court on Human and People's Rights to include corruption will also require more money. But the court right now is also struggling with its mandate just on human rights, on people's rights. So some argue that, adding corruption may also be adding another burden that could, limit what the court can do for the people. So as we sell the idea and as we campaign to you honorable members, these are some of the questions that will come up. What about regional bodies? What about regional provisions? But we're saying the court will not take away the standing of any regional agencies or regional bodies or even national ones, because they will work in complementarity. It will be the court of last resort, particularly for grand corruption, particularly for senior officials, that sometimes we are afraid to prosecute nationally. We are afraid to prosecute regionally, even continentally. If you take the continent, going back to the example we usually give, would you prosecute or take your cousin, your sister or your sibling to jail or prison? It is the same thing. I think in African spirit of brotherhood and sisterhood, it is difficult sometimes to go knocking on Botswana when you're in Zimbabwe and say, what are you doing? Or to even go to Zambia when you're in Tanzania and say, what are you doing? But when you have a body, if we could have a body that could be impartial and independent to do the work for us, that could be a public good. So we're proposing this court and we're hoping we will get your support. We're hoping you will talk to your members of cabinet, because eventually it will be them that will take the draft treaty, look at it, dissect it, because we will have a draft treaty ready in a couple of months to share with interested governments. So that treaty, we've tried to make it as robust and as watertight as possible, but eventually it will be our governments that will decide on what stays in it and what goes out. And eventually, if we could have about 30 countries from the world to establish the court, that is something that we can begin with. Now, the question would be, why are we pushing for the court in Africa? Apart from the rhetoric or the narrative we've had before of how international instruments are used to go after African leaders, why actually not have our leaders in African countries being part of the first cohort of it, or establishing bodies of the court? Because that way we can then have much of a say in the design, the structure, the operationalization of the court without any imposition from anybody. So we are going to our leaders in Africa and saying, be part of the establishing group so that it is your court as well. So that when you are in or out of power and your institutions are unable or unwilling to prosecute, to investigate grand corruption, prosecute grand corruption, you can actually have an avenue where you can find some justice against corruption. So mine is really to say, with all the presentations given, they have shown us what is happening at the regional level, but also the limitations that we face, not just at the regional, but at the national level, and that maybe having an international instrument could actually be one of the answers. It's not the only answer, but one of the solutions that we can push for in our global anti-corruption efforts. Thank you very much.
Thank you very much. Are there any questions? Thank you. Question from Honourable Member from Lesotho.
Thank you very much, Madam Moderator. There's so much corruption on this planet, and it's so difficult. It has become difficult to trust any institution. I have two questions for you. The first one is, one, you have touched on a very important issue of funding. Who will be funding this court? Because I understand there's a lot of money needed to administer or to run the court. Number two, I just hope, I support its establishment. I just hope that it won't be corrupt. And my question is, who is going to, I think you get my question. It's answerable to who is going to make sure that, or monitor, who is going to monitor this court? Thank you. Those are my two questions.
Thank you very much again. I'll be short and brief, I guess. In as much as the Honorable from Lesotho is anchored on the establishment about the funding and stuff, I just wanted to find out from you guys to see if you are saying it's an international court, anti-corruption court. So it means you came to us because did you get the approval from, or let me start by saying this. Us as Africans, before we can put something into action, someone somewhere has to agree. Let's say the European Union, somewhere, somehow. It becomes vibrant because someone's gave a go ahead on it. Then yes, we take over. Are you trying to tell us that already as SADC, you've got the go ahead from the European Unions? What happened? Because I know, like she was talking about the funding. I know when it comes to funding, it has been a very, very thorny issue on the operation of this committee, TIFI, which is very, very, very important, my chairperson. We need to be involved in all the meetings that I see around because, you know, it involves cash transactions. Now and again, there are transactions, so we need to be involved. So now if you're establishing this, does it mean you've got a thumbs up from the so-and-so that you know, or it's just a litigation method that you've decided as Africans? Yeah. And the second one, apart from the establishment, I would also want to get deep into in the issue of whistleblowers. Or honestly, you'd see in South Africa. Once you say something about an issue happening in some buildings, you're gone. You are really gone. And only you'll find escorting me as a member of parliament. I've got nothing to,
I've got nothing to fear outside. People love me the way I am. You know, it's easy for me. But then now a whistleblower, someone that is trying to save the pairs for a country, we don't align. We don't have a properly an enacted law for them. How would you address us on that, so that at least, you know, as soon as I get to Eswatini on Monday, I tell them the international anti-corruption is coming. You know, the whistleblowers will be covered. Funding is there. That is why I'm talking about the establishment. Thank you, Madam Director.
All right, thank you. Let me just take these two first, Honorable. Okay. Thank you, Honorable Member from Lesotho. You are right about trust. Trust is important. And the court will have to also earn the trust of the people by being independent and being impartial. Fortunately, this will depend on the different members of the International Anti-Corruption Court who will establish it, and its structure and how it will be run, the prosecutor, the office of the prosecutor, for example, and how the judges will be nominated or selected to the court. We have seen organizations or even companies that try to fight corruption also being corrupt or not complying to some codes of ethics. I mean, human beings are not saints. And I think that's where codes, you know, come in handy. But also, you know, advisory councils, you know, advisory boards that will also monitor, you know, the ombudspersons, ombudsmen, offices that can also monitor different instruments, not just the International Anti-Corruption Court. I think those are instruments that can be provided for as established by the member states. What we're doing as an organization is to coordinate the efforts and push for members of, I guess, of the UN Convention Against Corruption, the AU Convention, the SADC Protocol, to come together and see the need for the International Anti-Corruption Court establishing of the court. And then from there, it is entirely up to the member states to then design it and its structure, how it's going to work. And hopefully these will be men and women of integrity who will also put provisions and not put immunities, because the moment you put immunities for a particular group of people, then you are definitely guaranteeing corruption to seep in. The moment you put preferential treatment of any kind for a group of people, then corruption has already come in. So we're hoping that the people that will eventually represent different countries to establish the court will see the need to do away with immunities. One of the reasons why the Malabo Protocol is not really favored by most countries actually is because of those immunities that it has, that it offers to sitting, especially incumbents in Africa. So you are right. That is something that will have to be done and considered by those who will establish it. What we're doing as civil society organization and people, legal minds that are pushing for the idea and the campaign is to only offer. Earlier on, the Secretary General spoke about model laws. It's not really a model law, the treaty that we have drafted or that we're drafting, but it is a draft, like a working gift that governments can actually look at and say, at least we have 5 steps already done. Our drafters, our attorney generals can have a look at it and have something to work with. But eventually what we will end up with lies entirely with the governments that will establish the court. I'll tie that to what Honorable from Eswatini was asking. Have the people with money or the countries with money given go ahead? The countries with money have not given go ahead because this is a proposal. We are running a campaign proposing the International Anti-Corruption Court to all countries, including the countries with money. Africa also has money, by the way. And we're hoping that all countries with money, visible money, and power in the money and how it's used, and countries that have money but probably don't use the money in the way that strong countries use them, will also come together and see the need, to establish it. And there's a reason for that, how we are also even pushing for a lot of African countries to be involved from the beginning, to avoid instances where eventually there will be this saying or statements that this is a European court, this is an American court. We want this to be a global court. We want it to be an international court that African countries have participated in, that they have looked at the draft, shredded it, put it back together, owned it, because it will be their court as well. So I think that's what I can say about the approval from Europe and America or any other first world, if I may use that expression, countries. The issue of whistleblowers is very important. I don't know if it's unfortunate, if I can say unfortunately or fortunately, because this will be a court of last resort, working with national courts, it will probably vet cases taken to it by national agencies who would probably have some of the cases already having been dealt with at the national level or investigated at the national level. It will definitely force the court to deal with how to capacitate institutions to protect whistleblowers at the national level for grand corruption. I think it is important to underline grand corruption and kleptocracy when we talk about the International Anti-Corruption Court, because it will not take just any case. It will be grand corruption as defined by national laws, but also probably defined by the statute where it is eventually finalized by the member states who will establish the court. Yes, whistleblowers die. They get killed because corruption fights back. I worked for 2 years for a platform that protected and supported whistleblowers, so I know very well how they die, how they get killed, sometimes not even physically being killed, just losing your livelihood, having your kids lose their schools or having to leave private school. Because most of the time, especially in South Africa, just from observation, even in Zambia, the people who would report corruption would be your auditors, internal auditors, your accountants. So these are chartered accountants, people who were earning already, say, 100,000 rands plus. Now, all of a sudden, that's suspended because of retaliation for whistleblowing. Their livelihood completely changed, their lifestyle completely changed. Now they have to depend on donations from church or from people. It affects them mentally. So fighting corruption really requires the highest level of political will at the national level to protect whistleblowers. And the question then becomes, where does protection begin? Because with most witness protection acts, protection only begins when someone is going to court and becoming a state witness, for example. But by that time, that's like 2 years. People have been killed. If you take Babita Deokran, for example, or even the journalist in Malta who was bombed, because they were not state witness yet, because there was no case yet, they were killed. Some lose their lives, their livelihoods, their jobs, because the case is not at the courts yet. So we also have to, as members of parliament, we have to look at our whistleblowing laws or public interest laws or public interest disclosure laws and see how we change them. South Africa, actually, I think the PDA, the Public Disclosures Act, I think is actually quite good. I think it has like probably 85% good in it. And I think most Southern African countries could benchmark with the PDA and see how they can change their laws, because it does protect. In some ways, it implies protection from the beginning, from the onset of reporting corruption. Someone has to be protected. It gives the one who receives disclosures about 3 weeks to inform the one who has actually reported, to give them and tell them what the way forward is in some way. And I think most countries need to do that. Otherwise, we will lose whistleblowers, and otherwise we shouldn't even teach about ethics. Because when you teach ethics and integrity, you are actually creating whistleblowers. But then you are creating whistleblowers, but you do not have an ecosystem that can actually carry them when they report and protect them from retaliation and from victimization. So the court at the international level will have to make some provisions on how to capacitate national institutions to ensure protection of whistleblowers, even if it means adding a provision for whistleblowers in Witness Protection Acts, or having an independent Whistleblower Protection Act that has provision for witness protection of some sort for whistleblowers. So I think that's all I can say about that one. I hope that answers your question. All right, Member of Parliament from Malawi. Your question on funding. So and it'll also go back to the members, but also knowing how corruption is very profitable. Hopefully some of the proceeds that would have been repatriated, a certain percentage, this is just me thinking. I don't know what the member states are going to decide on. Maybe a certain percentage can actually go back also into to support the court, to sustain the court. We were looking at how the ICC is actually being funded, and apparently in 2021, about $168 million was needed for the court. But it's also, I think, depends on the processes and procedures of approaching the court and running the ICC. Some believe that it's because of the protracted, cases and how just the length of running cases at the ICC. So that the IACC will have to figure out how they shorten the time of prosecution, shorten the time of vetting, if there's even going to be such a thing. The ICC, I believe, has a pre-trial chamber, and that also takes time and also requires people to be paid. And that's something that we hope that the IACC will not need. So shortening the time of processing also means shortening what is needed in terms of finances. But eventually it will really be what member states decide on how their court will be financed. But I think innovative ways can always be found. If money has been taken, in the US, I think whistleblowers are given a certain percentage of whatever has been recovered. So the court could also be, financed in such a way. You recover some billions, a certain percentage can go to the court and help sustain the court, but it will depend on the member states. Yeah. Yes, sir.
Thank you. Thank you very much. In the process of answering the questions from my colleagues, Padre, you have answered my question. Suffice to say, this court is going to be international, and that means it has to get the nod of the governments, states. If I'm not wrong, most of these countries have already bodies which are fighting corruption. But you find that these bodies sometimes are rendered toothless because there is no political will. So I want to understand now how this one, the international one, is going to bite, to have power to prosecute in those countries. In the actual sense, those countries are not willing to prosecute corruption cases because the leaders are also involved in the corruption cases. And the secondary, you have mentioned you have likened this body to the ICC, but there's a strong feeling that the ICC most of the time only shows its power to the weaker countries, to the poor countries, and leave the powerful countries, the rich countries, scot-free. You find when it involves a president from Africa or some other weak country, poor countries, the court will show its power, its strength. Now, when it involves those superpowers, it becomes it is unable to prosecute. We have issues whereby a warrant of arrest has been issued for a powerful country, for a powerful president to be arrested. But he goes around scot-free. He cannot be arrested because he leads a powerful, a superpower country. So how can you marry this one if we have this international court to prosecute corruption cases? How is it going to be different from the ICC? Shortly, I think that's my question and part of my comment I submit.
All right, thank you, Honorable. It is not easy to actually enforce international arrest warrants. Even when countries have extradition agreements, it becomes difficult. I mean, we can only guess who this powerful leader is, who cannot be arrested by one particular, say, an African country for, say, crimes against humanity or for genocide or even aggression. And I think that's where also maybe the difference between a court that wants to fight corruption and a court that is fighting genocide and crimes against humanity also comes in that with corruption and grand corruption, especially where monies and funds are concerned and can be traced and can actually be found eventually in a particular offshore account. Because usually is actually the tracing, people say it's easy. You can always trace where money left and when it went, and then the different 10 accounts it went into, and then eventually going and being layered elsewhere. It is trying to repatriate that money back to the victim country that becomes a bit difficult because of lack of agreements between those countries and lack of court orders at the international level, because there's no body that has jurisdiction at that level. So it's a little bit different, that kind of process for going after someone for genocide, because it becomes also in a way subjective for some leaders. Let's say I find myself in Tanzania, but I'm also friends with the leader in Tanzania. This imaginary country, I'm not, targeting Tanzania. So I'm there, but we are also a member of, say, COMESA or AAC, EAC. It's going to be difficult for a member of Tanzania to actually look at me and say, for genocide, because it could also be something that they understand, because it becomes a little subjective when it comes to some of these crimes. But when it comes to financial and economic crimes, such as grand corruption, the evidence is usually there and it can be traced, can be investigated, traced, accounts looked for, different banks also looked into and trace back that money and help actually pin. And not only can one not be extradited, but those accounts can also be frozen. Assets can be confiscated. So even when we do not go, the court doesn't go after people criminally, some civil procedures or processes can be begun by member states. It may be that the Anti-Corruption Commission or the Anti-Corruption Directorate on Corruption and Economic Crimes is toothless. But there are other institutions that can actually appear before the court should the member country, the member state, actually allow for their statutory body to appear before the court. We, from the civil society side, we're also pushing for the court to allow for amicus, to also appear. So such as civil society, we have, Corruption Watch in South Africa, for example, is one civil society organization that has done an amazing work, not only advocacy and public education, but also, standing in with people and appearing before the courts for the people or with the people that need some support at the Constitutional Court. We're hoping that the International Anti-Corruption Court could also, open up. The member states will allow for that to happen and have a provision where civil society organizations and other statutory bodies could also appear before the court, so that should an agency find itself with a lot of political interference and that they cannot take a case, investigate and take the case. And for the DPP also, the public prosecution director cannot also, prosecute properly because of lack of good lawyers, for example, or maybe just lack of capacity, because corruption is complex and investigating it is actually also quite complex, that then the court could maybe be of some assistance in that regard. We are selling an idea, but it's an idea for us to all perfect. It's an idea for us to all work on. And these are great questions, but what if, what about? These are great questions that members of cabinet are going to look at, that our presidents are also going to grapple with as well. But eventually it's going to take great legal experts and legal minds of all the different countries that are interested to come up with a statute that would be good, that will help the court do what it's supposed to do. One, in investigating, two, in ensuring that they have got good evidence for the different cases from the different countries, and impartial judges who will then, prosecute and issue out orders, whether it's arrest or going after assets in other countries, especially. We may have our MLAs between Botswana and South Africa, but we may not have easy access to a bank in Japan if that money has gone to Japan, or even access to a yacht, a house in London. But having a court such as this one may actually give some access to those assets and to that money.
Thank you very much, Ms. Morapedi. If I may ask if you could keep your question until after the lunch break. I've been reminded that it's lunch, if you wouldn't mind. If we could reconvene at 2:30, then we're 2:00. 2:00, and then we'll start with a question from the honourable member from the DRC. Is that acceptable? Thank you. Back at 2:00. Thank you very much for your attention. I think in the interests of time, we'd like to continue with the questions that were pending before the break. And we'd like very much to call on the honourable member from the DRC to ask his question, and then we'll proceed from there. Thank you. Is the French translator online, interpreter? Okay, Honorable oh, sorry. Please go ahead. Or the person who's about to speak speaks French. Okay. Okay. Ah, ok, monsieur. À vous.
Merci beaucoup, madame. Je suis très content de te suivre ce soir. Je reviens par rapport à la protection des dénonciateurs. Et par expérience, j'ai dirigé un institut de recherche en République démocratique du Congo qui mène des enquêtes. Je suis allé à la CPI, à la Cour pénale internationale à Haye, par 2 fois. Je suis allé témoigner là-bas. Et vous pouvez imaginer les risques qu'un dénonciateur peut avoir. Je suis arrivé à la CPI, à la Haye, à cause des crimes qui se commettent en RDC. Mon institut fait des recherches et souvent la CPI me fait appel. Comme maintenant là, à cause des crimes qui se commettent à l'Est, nous sommes sur ce dossier et le moment venu, je crois que je pourrais aller à la CPI. Je voudrais vraiment vous recommander parce que la protection des gens qui témoignent, et maintenant qu'on parle des gens de la corruption, ça c'est encore plus grave. Vous pouvez imaginer les risques que les gens vont prendre. Donc il faut que ça soit, vous mettiez des garanties de sécurité parce que moi-même, je sais, pour voyager, parfois, je traverse, je vais au Congo-Brazza, je prends l'avion sous l'escorte de la MONUSCO et arrivé à La Haye. Donc, mon expérience comme dénonciateur doit vous édifier. Donc, il faut protéger des gens qui viennent témoigner. Et surtout maintenant qu'on va parler de la corruption où les gens, vous allez témoigner des gens qui ont détourné des milliards, des millions de dollars. Il faut que vous mettiez des garanties de sécurité. Merci.
Thank you very much, Honorable. I think yours is a comment that protection should be of the highest level possible. And you are right. We do need protection. Whistleblowers do need support. And I think it was said earlier that, that's within the national institutions and legal frameworks also have to come in and, put in place those protective measures. And it's actually up to us, then it goes back to us as citizens, as civil society, as the legislature, and push for reforms and push for enforcement to actually take place, because the court can only work in complementarity with the national bodies. But whistleblowing, really, the AU, I think last year or 2 years ago, had the year of whistleblowing. And I think it's something that needs to come back again, even at the SADC level, to really look into how, in our efforts to fight corruption, how whistleblower support and protection becomes one of the central, pillars that we embark on while we look into amending laws and or even improving the efficiencies of our institutions. I think that comment is a great one. It's noted. Thank you very much.
Are there any more questions, or can we move on to the next presentation? Honourable Member from Zimbabwe.
Okay, thank you, Madam. Mine is not a question, but it's just a short presentation from Zimbabwe. I heard in the morning the first presenter mentioned about Zimbabwe, on about oversight structures of anti-corruption. So I've decided to share with you our structures of anti-corruption in Zimbabwe. So in Zimbabwe, we have a Zimbabwe Anti-Corruption Commission, that is ZAC. It is a constitutional body established under the Chapter 13 of the Constitution with a mandate to investigate and combat corruption in both public and private sectors. Its functions are they are there to receive reports, conduct investigations, and refers prosecutable cases to the National Prosecution Authority. ZAC, it remains committed to its constitutional mandate, operating within existing legal and institutional frameworks to enhance integrity and transparency. We also have non-governmental oversight. This is Transparent International Zimbabwe. Transparent International Zimbabwe is an independent watchdog promoting accountability, transparency, and good governance through research, advocacy, and public awareness campaigns. Its key activities, they are there to publish the annual corruption perception index for Zimbabwe. They are there again to monitor governance trends and advocates for institutional reforms to strengthen accountability. Zimbabwe anti-corruption framework has a diverse and growing anti-corruption framework that includes oversight by ZAC, the Police Anti-Corruption Unity, and the Auditor General's Office, enable to broad-based response to corruption. There is growing institutional synergy and collaboration in the investigations and preventive initiatives. So Zimbabwe commitment to fight corruption, the government has enhanced the legislative framework, including strengthening the Anti-Corruption Act to empower ZAC further. Zimbabwe collaborates with international partners such as UNODC and adheres to SADC anti-corruption protocols to build capacity and share best practices. Public awareness campaigns and whistleblower protection have been introduced to foster citizen participation and encourage ethical conduct. So in conclusion, Zimbabwe continues to make significant strides in the fight against corruption through legal reforms, institutional capacity building, and civil society participation. These interventions demonstrate a strong national commitment to transparency, accountability, and alignment with the regional and international anti-corruption standards. So thank you, Madam.
No, thank you, Honorable. Most countries in Southern Africa do have some anti-corruption legal framework and to some extent even institutional framework in place. I think what we usually cry about from the civil society side is the number of scandals we read about in the media and the number of prosecutions or lack thereof at the National Prosecutory, Authority or Director of Public Prosecution level or at the court level. But definitely when it comes to legal framework, most countries do have the legal framework. And I don't know if the issue or the challenge is observance of the law when it comes to especially grand corruption, where we don't see people being prosecuted. But of course, the issue of political interference come into play at times. It plays a huge role. And then we can then also say, but how can we help our governments when it comes to the problem or the challenge of political interference? Because it seems like we cannot avoid it. The question, would you take your cousin or your comrade from your political party to court or to prison, always comes up, will always come up. And because most of the time it is difficult. No, we may not. But if we have independent institutions that can do that can prosecute without any favor, we will see the rate of prosecution going up. We will see whistleblowers being more protected. We will see, there's an example of a case of, I think we'll call it electoral corruption, where in a particular country, I will not name, we had people from the police who reported how they were forced to vote on behalf of other people. And they reported it to an anti-corruption commission because they regarded it as corruption. But instead of the accused being investigated, we saw the police men and women who reported actually running for their lives. So sometimes it's just those little challenges that we face as citizens, even when we have anti-corruption agencies, when we have civil society organizations as well that try to advocate, teach, and raise awareness about corruption, how to fight it. But thank you very much for sharing about the efforts in Zimbabwe. And I'm sure the efforts in other SADC countries as well. I think if we can continue pushing and asking for enforcement and observance of the law, the laws that these institutions are supposed to actually implement and execute, we may actually go somewhere. Thank you very much, Honorable.
Thank you very much. Are there any further questions from the floor, or could we continue with the next presentation? Thank you very much. In that case, I'd like to call A.G. Houstrup, who is the GGA Group Vice Chairman, to share a bit on the work of Good Governance Africa. Thank you.
Thank you very much, Ruth. And I hope that coming after lunch, I wouldn't bore you to sleep, but I'm going to be very brief and to the point. Honorable members of parliament, distinguished ladies and gentlemen, a lot has already been said on the effects of grand corruption on the development of Africa, and particularly the SADC region. The significance of the IAC court, the International Anti-Corruption Court, in turning the situation around has also been underscored by many of the speakers this morning. Two questions that have arisen from this morning's session are, one, how do African states, especially our region, how do we domesticate the fight against corruption so that the International Anti-Corruption Court becomes the court of last resort, as it is expected to be? So that's something to reflect upon. The other is, how do we reduce the corruption that goes on in each of our countries? And I thought if I talked a bit about what we do in GGA, we would all come to an understanding of what needs to be done and what potentials there are for collaboration between your countries, and in particular, the Parliamentary Forum and the Southern Africa Regional Office of GGA, which is based here in Johannesburg. I hope that when I'm done, it will be clear to you all that collaborating is a must. Let me start by sharing with you a little bit about how GGA started. GGA, the Good Governance Africa, was started in 2014, a little over 10 years ago, after consultations with leaders in academia, civil society organizations, government agencies, and the private sector in Africa, Europe, and North America. The conclusion they all reached was that Africa would only fulfill its enormous potential if it addressed the gap in ethical leadership and good governance, and significantly reduced corruption in public and private sectors. GGA was established to help realize these goals by providing rigorous research, policy options that are both evidence-based and practical, by advocating for inclusivity, transparency, and accountability, respect for the rule of law, and fighting corruption. In the last 10 years, we have made some progress and we've learned a lot. We know, for instance, through research, that many governments in the SADC region fall short of the expectations of their citizens in delivery of social services, in inclusivity, in transparency and accountability. We know that many countries have high youth unemployment rate, that the economic investment and growth rate has stalled. We also know there is a high deficit in infrastructure, affordable healthcare, and high quality education. We have evidence through research that shows many of these shortfalls can be improved upon by addressing deficits in governance, shortage of ethical and competent leadership, and by reducing corruption in both public and private sectors. When we analyze the governance challenges that Africa faces, several recurring themes stand out. These include weak systems of accountability, inadequate mechanisms for ensuring transparency and accountability, weak institutional capacity, medium to high levels of corruption, limited oversight and fragmented regulatory frameworks, a lack of competence and/or ethical leadership, nepotism, and Generally, mismanagement of resources are also pervasive. Many of our countries within the SADC region suffer from outdated information systems, a lack of capacity, and insufficient training among public servants and service providers. These often lead to severe gaps in many areas of service delivery. They are responsible for stalled economic growth and social development, and among the citizens, these have resulted in a lack of trust in their government. Equally pressing is the issue of insufficient participation in governance by many citizens, including the youth. When democratic practices do not fully engage the population, policy formulation lacks the required inclusiveness, particularly alienating society's vulnerable groups and exacerbating social inequalities. Apart from these mostly administrative challenges, there are several other contextual issues that further complicate our governance landscapes. Prominent among these are issues of peace and security, with many lingering conflicts spread across the continent and many weak institutions of state incapable of addressing them. This situation has sometimes led to regional instability and has created opportunities for corruption to fester. High youth unemployment is another major challenge throughout Africa and the SADC countries. With many young people struggling to find meaningful employment, a great number of them have become despondent and disillusioned. They are anxious and angry and prone to develop antisocial behaviors, including not turning out to vote at elections, and a general disdain for participating in democratic processes. Africa's next generation is not being adequately prepared for service and leadership. We are instead losing many of our young population to anger, hopelessness, and apathy. There are also the interconnected issues of natural resource governance, environmental stewardship, and climate change. Despite the abundance of natural resources in many countries, we struggle to turn Africa's endowments into wealth for the majority of our people. Instead, these resources have fueled conflicts and enabled corruption to thrive at high levels, prompting some to conclude that Africa's natural resources are a curse, not a blessing. I have highlighted some of the more prominent of the governance challenges we face in SADC and Africa as a whole to introduce the work of GGA and the requirement for effective partnership with organizations such as the SADC Parliamentary Forum. How does GGA address Africa's governance challenges? And what role can the SADC Parliamentary Forum play in advancing our mutual goals? Focusing on research and publication, GGA started in 2014 as a think tank here in Johannesburg. We have since evolved. We now have regional centers in Accra, Ghana, Addis Ababa, Ethiopia, Johannesburg, South Africa, and Lagos, Nigeria. Through research and data gathering, evidence-based policy advocacy, and practical intervention programs, each GGA center is addressing the governance challenges most prominent in its area, using methods most effective for achieving results and impact. Here at the Southern Africa Regional Office of GGA, our Governance Insights and Analytics program leads our research and analytical work using the Governance Performance Index. GPI is a proprietary tool developed by GGA and our partners in the selected municipalities in South Africa, and it has been able to rank many of these municipalities and their subnational authorities based on their performance in service delivery, administration, planning, monitoring, and development initiatives. The GPI is particularly useful in helping municipal governments to monitor and self-evaluate, thereby assisting them to develop intervention strategies that will improve their performance. We are now carrying out the African Cities Profiling Project, not only in South Africa, but in cities across the Southern Africa region, with Johannesburg, Harare, Lilongwe, Lusaka, and Luanda completed to date. This project offers in-depth analysis of major urban centers, providing actionable intelligence to drive improvement in governance. The GIP is also conducting research and analysis into voting patterns, and tracking elections as they occur in various countries. Another of our signature programs is the Natural Resource Governance and Climate Change Initiative, which addresses the governance challenges in the mining and extractives sector, including environmental stewardship and climate change. Included in this orbit are issues related to household energy safety, with emphasis on women's security in energy access. We are active participants in the annual Mining Indaba Week and similar events, highlighting our interest and concern in this vital area of economic investment and resilience. Our peace and security program focuses on the challenges posed by insecurity and violent conflicts in many parts of Africa. Through active participation in peacekeeping missions and serving as the Secretariat for the Peacekeeping Advisory Group, the program provides expert analysis and strategic guidance to a broad spectrum of stakeholders. A major event in our anti-corruption program calendar is the annual GGA conference and workshops. We have consistently called attention to the scourge of corruption and focused on the fight against corruption in public and private sectors. We have dedicated special editions of our flagship publication, Africa in Fact, AIF, to the global menace that has a particularly devastating effect on our social and economic development on the continent. A special international edition of AIF that focuses on the International Anti-Corruption Court, IAC Court, will be published next month. Our partnership with III on the campaign to establish the IAC Court as the convening partner for Africa is only the latest manifestation of our unrelenting effort to focus attention on grand corruption and our effort to significantly reduce it. Finally, I would like to mention our Youth Empowerment and Development Program. Africa has the youngest population in the world. Our youths represent our future and must be encouraged and empowered to fulfill their potential. They must not be allowed to succumb to cynicism and apathy or repeat the errors of the generation before them. Our annual Girl-Child Dialogues is one of our youth empowerment programs through which we focus attention on this particular demographic. Under the same umbrella of our youth program, we plan to launch a 10-year project to recruit 1 million young Africans, engage and train them in ethical leadership, good governance, and the fight against corruption. This Africa-wide program is called YAG, Young Advocate for Good Governance. It will be launched here in the South Africa Regional Office and subsequently rolled out to all our other centers. These are some of the work we are involved in here at the Southern Africa Regional Office of GGA. Our plan for the next phase of our evolution, that's 2025 to 2034, is to grow our current programming and expand our geographic reach and footprint in Africa. We currently have 4 regional offices. This will expand to 9 by 2034. In the SADC region, most of our work is currently concentrated in South Africa, Zimbabwe, and Mozambique. We also have footprints in Malawi and Zambia. Our hope and desire are to eventually cover all the countries in sub-Saharan Africa. Our mission is to improve the lives of our citizens through good governance. We will continue to be a credible, independent voice, partnering with governments to promote ethical leadership and good governance in Africa. Through our rigorous research and advocacy, we will continue to provide effective policy options, build institutional capacity, and strengthen transparency and accountability and the rule of law. To achieve our growth and expansion plans, we recognize the strategic importance of 2 essential pillars. 1, we must forge meaningful and collaborative relationships with strategic partners and important stakeholders. Secondly, we must intensify our efforts to grow and diversify our source of core funding to meet our growing needs. On both accounts, we will be counting on the support and partnership of SADC and similar regional bodies. Both GGA and the SADC Parliamentary Forum have several areas of mutual interest and potential areas of collaboration. We hope to be able to grow our relationship for the benefit of our people. Thank you all very much, honorable members of Parliament, for your attention.
Thank you, Deji. Are there any questions from the floor? No? Madam Chair?
Não é bem uma pergunta, mas queria fazer um comentário acima de uma coisa que foi aqui dita. É a questão de nós contarmos com os jovens. Eu quero dizer que nem sempre isso funciona. Nós antes criticávamos o governo porque punha pessoas mais velhas e por isso é que se envolviam em corrupção, em casos de corrupção. Mas nós temos neste momento um escândalo grande de corrupção que eu já fiz referência aqui, da Administração Geral Tributária, onde a administração é formada essencialmente por jovens, a começar pelo presidente do Conselho de Administração, os diretores, todos são jovens, e o escândalo do maior arrombo que o governo teve agora de cerca de 30 mil milhões de dólares foi praticado por jovens, ou está a ser praticado por jovens. Este caso é um caso recente, está entregue agora, ainda está sob investigação, inclusive, mas só para dizer que não sei se devemos ir por essa linha de contar só com jovens, porque achamos que os jovens não estão despidos do espírito de corrupção, pelo menos no que toca ao exemplo de Angola, isso não está a acontecer, não está a acontecer e é de facto com muita tristeza que nós dizemos disso, porque são nossos filhos, são jovens que têm a idade de ser nossos filhos, que neste momento estão a cometer os atos de corrupção e, em alguns casos, até de forma mais violenta do que o faziam as pessoas mais velhas. Manter esse comentário que eu gostaria de fazer. Muito obrigada.
Honorable member, thank you very much for the very purpose of the Young Advocates for Good Governance, the program that GGA is embarking upon, is the example that you have just given. Africa has the youngest population in the world. 70% of sub-Saharan Africa is younger than 30 years old. And they are the future. But if the future is already behaving badly, then that future cannot be promising. And that's why it's important to start teaching our young people the importance of accountability, of ethical leadership. And this Young Advocates program, we believe, to start recruiting young people as young as the age of 14, so that they would have acquired such knowledge and competencies and skills in leadership even before they get to university. You see, as the Honorable Member of Parliament mentioned, sometimes it's already too late when they get to university. So you have young people, 25 and 30 years old, already committing corrupt practices. This is because they never had a grounding in anti-corruption at an early age. Our hope is that this is not repeated throughout the continent, but I'm afraid no one can guarantee that. So it's important for us to put more attention on our young ones, because if we think that just because they are young, they will not be corrupt, then we would have been making a mistake. And so I thank you very much for bringing up the example of Angola. It just goes further to cement the need for such a program. Thank you.
Any further questions from the floor? Thank you. Thank you, Deji.
Thank you very much.
So now I would like to call on Mr. Robert Rose, our founder and GGA Group Chair, to make some closing remarks.
Thanks, Ruth. Good afternoon. Honourable members of Parliament, ladies and gentlemen. It's my honour to be able to meet the SADC parliamentarians for the first time. Deji has told you a little about what Good Governance Africa is trying to do. What we intend to do and are going to do is to make Africa the continent of the future. It should have been the continent of the future a few decades ago, but we've messed up. But we're not going to mess up in the future. We're going to put it right. And you good people here are going to play a very important role in putting that right. We've heard about corruption, and I think most of us here are on the same wavelength that we have to remove it. It's a criminal disease. It's a disease against humanity, which has caused poverty, lack of education, lack of health facilities, lack of everything, lack of jobs, lack of investment. And I will be saying a few things because there isn't time to say too much. But the fact is that corruption is actually far greater and far more damaging than all of us here believe. And I'll touch on that from in a couple of minutes' time. We're at a crossroads today, and I am sure that all of us here intend to take the high road and abandon the low road which we're on at the moment. We have an immense opportunity which the International Anti-Corruption Court has given us to show the world that we intend to sort ourselves out. It is not an African problem, it's a global problem. The worst continent actually is Asia. The next continent is Africa, but because we are so poor in relation to the rest of the world, we are 4% when we should be 25%. Because we're so poor, the impact is so much greater. And that's why we now must sort this out once and for all. We all of us, have to play a part in doing that. And the advent of this International Anti-Corruption Court, and you've asked lots of very sensible questions. We have to get it right. We have to get it right for everybody, not just Africa. The biggest beneficiaries are actually the world. And because the world is going to be the biggest beneficiary, the impact and the positive effect on Africa is going to be even greater. So please, we have to all get behind this. And I'm sure we in Africa are going to do it in the right way for what we need in Africa. The days of the big kleptocrats and the corrupt leaders is coming to an end. They are already aware of it. And we are aware that some of them are aware of it. And they're making their plans. And I hope their plans will be to stop it, because that's what they need to do. We have to eradicate this disease. It is a disease. And if it spreads from the top, then it grows to the bottom. And that is the disease which in 2003, the United Nations introduced anti-corruption laws. They all agreed to it. 189 countries signed it, including all the bad ones that we're aware of. But of course, it's now 2025. And what has happened? Instead of corruption reducing, it's increased steadily, because very few countries, not just in Africa, across the world, have not imposed the laws which they've all introduced into their countries. Most countries in Africa and everywhere else have very adequate laws. They need improving. Everything always needs improving. But the fact is that they haven't imposed them. They haven't imposed them because some people didn't want to impose them. And hence they reduced all of the structures that are necessary courts that are not corrupt have become corrupt in many countries. There aren't enough prosecutors. The police force is useless. And as a result, corruption has spread. The disease has spread. We're all subject to this terrible disease, which we all want to remove. And now we're going to remove it. We're all going to work hard to remove it. Many of the wars that we have in Africa, 4 million people dead in DRC. The DRC man, I think, has left. But I mean, it's a tragedy. It's a tragedy all over the place. And often it's just through greed. We're seeing it in Eastern DRC today. So corruption is the root of the evil, and we have to deal with it. So the outcome of the International Court, which we're all going to make sure happens, and happens in most countries in the world, because 95% of the people on this continent and in all other continents are sick and tired of the waste, the poor leadership, the disrespect that parliamentarians have therefore got when you're there to do the best for your people. But the image that you have got, which most of you are unjustified to have, is that you're all involved in corruption. Well, I'm sure you're not all involved in corruption, but I'm sure all of you want to see the back of it. And then we will restore our respect, and we'll start getting better leaders, because leaders in the future will not want to go into politics to make money. That, in fact, will become so clear that I'm sure that our whole culture of better governance and better leadership will start to rapidly evolve, probably quicker than you think. So we all have to set an example, all of us. And the disease of grand corruption will eventually spread to petty corruption, so that nobody in society will tolerate corruption at all levels. It's a disease that we must get away with. It's no longer acceptable to any of us. And how long will that take? Well, I hope it won't take more than 10 years. And if we all work at it, it will happen. Not just in Africa, everywhere. Everywhere. Leaders of the world, many of them have no respect from their people. I've met a lot of prime ministers in the last 20 years, and I can honestly say to you that I can only look at 5% of them in the face and say, you're a genuine, honest person who's doing 100% for your people. There are very few, but that's got to change, and it's going to change. Somebody asked, well, there were some very good questions. One question was about monitoring it. The fact is that 5% of the world's GDP is grand corruption on every continent. Do you know what that means? That means over $2 trillion every year. Can you imagine what we all could have done in the last 10 years with $20 trillion? There would be no starvation. There would be great education. There would be great medical services. And what do we have? Because a few greedy people have stolen our resources. Do you realize that 25% of Africa's annual developed wealth, its GDP, is illegally exported? Can you believe that? Well, when we're only 4% of the world's GDP, when we should be 25%, that's your answer. Not only have we not invested the money that we've created on this continent, but many investors who want to come to Africa have felt unable to do so. Unable to do so because they waste time negotiating. They can't reach a deal which they know won't be honored in a few years' time because the people they're talking to have no respect for ethics. So that is why Africa has not grown as fast as it should have done. I came to Africa when I was 21, 1959, and there was great hope then, great hope that this young, undeveloped continent would be able to grow because it has everything. It even has good climate, and hence we don't waste things on energy unnecessarily, etc., etc. We're blessed with everything. Now we have to put it right, and we're going to put it right. And from my experience of business across Africa, and my businesses are actually in 44 countries in Africa. So I've seen Africa. Some countries with no governance. Can you believe that? No governance, no law and order. It's unbelievable. And so we can put it right. And because we're starting at such a low base, we can actually put it right much quicker than old, complicated countries which exist in many parts of the world. I mean, the red tape in Europe is just unbelievable. If we can't catch up with Europe and America in the next 40 years, then we've missed our opportunity. We can catch up the rest of the world because we've got no baggage. We can catch up and we can overtake them because we actually have everything. And they know we have everything and they want to invest here. So we want to invest everything ourselves, and we want everybody from all over the world to come here and be welcome and stop the unemployment. There should be no unemployment in Africa. Some countries, there's 90%. Can you believe that? Well, I've seen it, so I can believe it. And that's why good governance is here to help everybody help themselves. Nobody can do it on their own, but working together, we can make tremendous progress. So I mentioned the benefit to the world. So the benefit to the world is not 5% of their GDP. In fact, it's going to be many times that, because throughout the world, not just Africa, development has been held back. Decision-making is so much slower when it should be so much faster, because everybody is doing the same, they're on the same wavelength, and nobody's holding back because of some stupid guy who wants to make some money. And so the opportunity is there for us to take. And you, as parliamentarians, are going to be one of the leaders to help your communities, help civil society, all start working together to get this right, because we can get it right. So the positive effects of reducing corruption internationally is going to be absolutely fundamental. It's going to be unbelievable. And so TIFI, who have done an incredible job, I think somebody inferred that people were making money. Judge Mark Wolf and Richard Goldstein and 300 or more people have given their time for nothing. They've given their time because they are sick and tired of seeing their leaders do nothing. They've seen their leaders knowing all the problems. We know all the problems. We learned all the problems. We're all experts on corruption, but nobody has imposed their laws. And now we have to have a backup system which will make sure that they impose their laws. Every country must sort itself out. The International Court doesn't want to sort anybody out. They want everybody sorting themselves out so that we can have a prosperous world, happy people. There should be no poor people who've had resources removed from them and are living a very poor quality of life. It shouldn't exist. We've made so much progress in the world with new innovations and new technology. It's unbelievable. It's actually unbelievable, the progress that the world has made. But unfortunately, 30% of the world has not participated in that because of a few greedy people. And so we're going to sort it out. And so with all your help, we are going to make Africa the continent of the future. Thank you very much.
Thank you, Robert. Are there any questions from the floor, or can we close for the day? So on behalf of TIFI and Good Governance Africa, I'd like to thank you all for your attention and engagement today. We really appreciate your support and your interest. And I'd like to hand back to the SADC PF for the final closing. Thank you.
Thank you so much for that. It is now my singular honor to invite the chairperson of the Standing Committee on TIFI to deliver her closing remarks and officially declare that this meeting should be closed. Honorable Mendes.
Muito obrigada a todos. Nós tivemos hoje este workshop que tratou do tema sobre a promoção da governação através da integridade econômica e empresarial, exploração do papel do proposto Tribunal Internacional contra a Corrupção. Tivemos oportunidade de ouvir várias palestras, mas quero, acima de tudo, destacar a última intervenção do Sr. Robert Rose, que para mim foi de facto a cereja em cima do bolo de tudo que nós tivemos aqui a tratar ao longo do dia. Ilustres membros do Fórum Parlamentar da SADC, distintos convidados, minhas senhoras e meus senhores, chegamos ao fim da nossa reunião e agradecemos sinceramente aos senhores e às senhoras deputados pela participação e pelas contribuições valiosas apresentadas ao longo do dia. A vossa participação ativa e o compromisso consciente demonstrados nessa reunião foram imprescindíveis para enriquecer o debate que tivemos aqui. Permitam-me manifestar gratidão aos nossos palestrantes da Integrity Initiative Internacional e Good Governance África pela partilha dos seus conhecimentos e experiência no combate à corrupção. Enquanto representamos os nossos povos, é imperativo que a nossa liderança assente firmemente nos princípios da boa governança. Estes princípios de transparência, prestação de contas, participação e equidade na tomada de decisões e afetação de recursos são específicos para a base do nosso papel de fiscalização. O nosso objetivo é minimizar a corrupção e maximizar o bem-estar dos nossos cidadãos, o que exige de todos garantir que as instituições públicas façam uma gestão de recursos de forma eficaz, respeitando o Estado de Direito, os direitos humanos e prestando serviços de forma eficiente e equitativa. Gostaria também de agradecer ao secretariado da SADC pelas apresentações perspicazes. O conhecimento partilhado está estreitamente alinhado com o mandato da Comissão de Comércio, Indústria, Finanças e Investimento. Ao cumprirmos os nossos deveres constitucionais, estamos agora mais bem informados para promover a implementação dos protocolos da SADC nas nossas circunscrições. Como sabem, o Fórum Parlamentar da SADC existe para intervir nas questões regionais através da ação parlamentar, sendo fundamental o compromisso contínuo de Vossas Excelências para efeitos do cumprimento desta missão. Minhas senhoras e meus senhores, antes de concluir, quero apelar a todos os membros da Comissão para nos envolvermos ativamente nos esforços da criação do Tribunal Internacional Anticorrupção, que com certeza será um instrumento que vai ajudar na mitigação dos casos de corrupção que assolam os nossos países. Agradeço finalmente à senhora secretária-geral, senhora Boemo Secoma, e ao secretariado do Fórum Parlamentar da SADC pelo apoio contínuo e profissional à comissão, o que nos permitiu trabalhar de forma produtiva. Muito obrigada a todos e tem encerrado, então, o workshop.
Thank you, Honorable Chair. Honorable members, Honorable Chair asks that you indulge her and allow the Chandler Institute do a 5 minutes presentation on the model law on PPPs, just for 5 minutes, please. Thank you.
Good afternoon. I know I'm probably standing in between people in the weekend, so we'll try to be very quick. But thank you so much for just giving us this slot. I'll try to make this presentation brief. It's basically an update to the TIFI committee on the progress that we're making working on the SADC PF on the model law and public-private partnerships. So please give us a few seconds as they project the presentation up there. So just a brief update. I think I won't get into much detail. My name is Ron Chari. I am with the Chandler Institute of Justice. We're working with the SADC PF to develop a model law on public-private partnerships. And the presentation is just going to be an update. I think I'll skip most of it and just focus on just give an update on where we are in the process and the kind of next steps that are going to take place. So we have concluded the MOU with the SADC PF and Chandler Institute of Justice, CIJ, and I've agreed on a work plan and roadmap. We're currently working on a position paper, which is pretty much a gap assessment of the 15 countries that constitute the SADC PF to assess the gaps in existing legislation and make recommendations on what needs to go into the law. And then based on that, we'll conduct wide stakeholder consultations and then leading into the drafting process of the model law, review and validation, and then we're targeting to have adopted by plenary once we've concluded the wider consultation process. Yeah, and then this is the last slide, and we're going to be working with the TIFI committee throughout the process, but there are various entry points. I think that the SADC Secretariat, SADC PF Secretariat is going to reach out to you. But getting insight and guidance from you, I think we've already been getting some of that from your respective jurisdictions on some of the issues I think that need to be covered. Just oversight of the process and accountability, and then alignment with some of the, I know there are some countries where I think the processes that are currently taking place of developing PPP laws or revising the legislation on PPPs, and then also going to involve you in the consultations, and then also training and capacity development. Yeah, so that's my brief presentation. Thank you so much for your time. Still around and I'm happy to take more questions on this process. And then for those that we've not had an opportunity to talk about Chandler Institute of Justice, we're still around after this meeting. But thank you so much and have a pleasant weekend.